Well, and thank you here with us the trying times. Welcome here online and online. Yes, thank you for joining us to arbitration court topics that we speak today. Since unfortunately war going on and it's a deal for Ukraine and for every organization, I would like to begin with the following. We need great work to the defender of our country. For here, our for Ukraine, we have men. Unfortunately, many of them already died in the battle. So close to us. Yesterday, and people died. He is the area of law. 2 years he worked holding senior office at the staff of the parliament. He was also a presidential legal. Uh, he helped to form the leadership of the support the International Arbitration operated in Ukraine. That is also and recently and he was very less. Please see the war dictates its terms to us. Way back in 2018, our purpose was to uphold the rights of arbiters, and so now measures. If I'm not mistaken, there's a on. Unfortunately, aircraft in the air. That is why just we see cafeteria is in the cafeteria. You get a coffee
So basically, as I'm
in
saying, we'll
room
move to the shelter.
conference.
Our meeting will still be broadcasting,
Uh,
And
You broadcast it.
so actually, that room in the shelter is good enough to actually uh, where we can all fit. So we have quite a big number of
We have
registered persons. We have now in the room
136
offline
participants of
about 80 persons, which certainly is a sign of importance to our conferences that we conduct every year online. But uh, through online, we have a number of participants from other countries like Poland, Sweden, Czech Republic, etc. Most of them are lawyers, practitioners. They are lawyers, consultants to enterprises, aid to enterprises, representatives of civil society, of course, and of judiciary. And I'm pleased to state that. Actually, we were expecting Konstantin Nikolaevich. We wanted to greet him with an outstanding event. Judgment of Grand Chamber of the Supreme Court as of 1st November. I suggest that all of you go through it and learn it. That's a judgment is pro arbitration. I'm not well aware of the case law, but probably that's for the first time in the history of judiciary when the convention as of 1958 was applied, according to which arbitration judgments are to be fulfilled, and Ukraine is responsible for the execution of such arbitration judgments. So I express my thanks to actually the justice who wrote that statement. Now, the Grand Chamber acted as arbitration, commented the obligation of the state to comply with arbitration agreements. And the third point, which is even more important, uh, there was judgment of Grand Chamber of 2017, but this time the Grand Chamber changed it. And it stated that there may be comment um, within the arbitration judgment that would apply to any third parties that did not sign the arbitration agreement. So I'm very thankful to esteemed justices of the Supreme Court who delivered this judgment of high for arbitration and for the future of arbitration. So I think it's just continuation of the policy that was launched in 2017. And indeed, I'm very happy with that. And I think that all our arbitration and business community will certainly welcome this judgment by the Supreme Court. As you know, current arbitration readings is that's the 10th session. So to conduct such readings when there is COVID pandemic and especially the war, certainly stresses the importance of our institution. We probably missed only once this conference, and the fact that we have 290 individuals registered during the war certainly stresses the significance of this conference for all of us and for the whole arbitration community, not only Ukraine. And also that shows how interested is the public in the activities of our arbitration institution. There is another important point about this arbitration readings. They are to commemorate the birthday of creator of Mr. Pobirchenko, academic Pobirchenko, who Actually, today is his birthday, 100th birthday. And we certainly need to commemorate that. But as you know, the governmental district in Kiev City is closed. No access. So actually, the headline court put flowers to the commemorative plates at the building where he lived. And uh, I'll tell you, by some reason, they always put a light into my eyes, so I can hardly see the audience. But well, that's the technology. Anyway, so Oksana, you certainly should be proud of your father. He had number of very multifaceted activities. I don't want to speak in details, but he was the one to lay foundations uh, of International Arbitration Chamber with the Chamber of Commerce of Ukraine that actually has made it possible for our institutions to be operational for more than 30 years. And he married consistent that he used the global standards of international arbitration. He implemented them with consideration of peculiarities of Ukraine, our mentality, our legal culture, and many other points. So this experience, and I'm repeating it again, well, there are many attempts, to copy paste some international practices and apply them to Ukraine would not always mean that it's their experience would work. So I think that these foundations laid by the academician, uh, he, with that, he stressed what we are talking about, the answer to the key question, who will be the judge in the disputes, how you select arbiters who would be objective and impartial. 30 years ago, he introduced the notion of integrity, which was included into the Constitution of Ukraine in 2017 as a key feature for a judge. So that's a principle that we support and continue implementing. What else would I like to say? We actually emerged successfully from the COVID the pandemics, and we managed to adapt our institutions to the conditions of the war. Although adaptation probably is not the right word here, I would say we managed to keep being operational even during the war. We'll certainly discuss later some positive and negative trends related to the war. But my first point is that we managed to uh, be in line with the general policy implemented by the President of Ukraine and the government of Ukraine. So every institution in Ukraine during the war is supposed to continue performing impeccably, and that also applies to constitutional bodies. And actually, judiciary then followed our path. We are to defend infringed rights of enterprises or citizens, no matter what country they come from. That's point one. Point two, we arranged uh, internal relations, interrelations during the martial law. We did that. Uh, so we do something in parallel, but we do whatever we can uh, to ensure security of participants of arbitration process of the arbiter staff members. This is our unique experience showing that we are on the right path. Right after the start of the war, we admitted more than 50 claims. This year we will achieve the number of 600, and I'm sure uh, we will do that. I'll tell you that activities of any arbitration institution, the indicator of the performance is how many cases they consider, how often business entities file claims with the court. Now we are working on the new rules of procedure, more importantly than rules to consider investment disputes. And as the chair of the parliamentary committee um, is late. Uh, well, he's the one who monitors our activities as member of the parliament. Um, we've been introducing for a long time um, uh, the so-called compliance policy because it's every time more often that we um, uh, are to pay attention to both facts and procedures. Uh, uh, so we are trying to be in line with modernization of activities of any arbitration institution, which is actually the guarantee. And I rely on the session. I'm waiting for the session where the representatives of our institution will share with you some information on what mostly they are working on. Once again, I want to thank you for participation in this conference, and I'd like to invite you to hear um, moderator and speakers of the first session. Let me introduce to you moderator of the first session, Tatiana Mr. Doctor, PhD in law. Thank you very much for accepting our invitation because she used to be Secretary General of Kiev Administrative Court. Thank you for coming back to your duties. So, Tatiana, please take your seat. For me, it's a great honor to be moderator, and I'm looking at the audience, and I can say that we can have very good memories about um, our speaker. About the our colleague who passed away yesterday, and all of us, in fact, are his uh, alumni. And I'm proud of saying that I was the alumni of Igor Gavrilovich. If you wanted to learn from him, you would get this vision of the whole universe, legal universe. I'm very happy to see all of you here, and I'm very happy with the fact that uh, this important feature will be always with us. Important fact that we remember that this professor and we remember what kind of human he was. Now we are moving forward with a very interesting topic. It seems to me that I remember the words stated by William Park, quite a famous professor at one of the conferences. When he was delivering his speech, he commented that, let's say, in the real estate sphere, when there is a question what really runs this world of real estate. I mean, location, location, and again, location. But if we get back to the arbitration and we try to think about a triad running the arbitration, I would say something very similar. Arbiter, and again, the arbiter. So this first session is devoted to the question how you do this choice, which may be decisive not only for arbitration proceedings, but have a crucial meanings which will uh, determine the outcome of the dispute. So I'm happy to tell you that we invited very interesting speakers who can present us with different views of how to select an arbiter. One point of view is institutional. What institutions should be involved, how they should define the arbiter, points of view of a legal representative of a party. When we are talking about the parties, it's not something virtual for us. They are very specific individuals who will decide on the selection of the arbiter. And one more point of view is the one of the arbiters, because they do not operate in a vacuum. The arbiter is guided by a number of points which are the same for everybody. But when we have a panel of arbiters, we deal with three arbiters who are to decide on the dispute. And I do hope that the discussion will be interesting and maybe to some extent intriguing because, as usual, partially these matters are beyond the attention and knowledge of the parties. I am a bit nervous because I'm going to invite quite outstanding people here. So the first speech will be delivered by Professor Patricia Shaughnessy, who has been working for many years with Stockholm University. She is an expert in international arbitration, international law, and actually important attributes of Patricia include the fact that their personal dedication and her love for Ukraine certainly contributed is a situation when many young arbiters pass through the school that she offered to Ukrainian students and invite that Ukrainians to Stockholm LLM because she realized how important for Ukrainian society is to have highly educated people who are highly educated and who are experts in international arbitration. I'm very thankful to Patricia for this many years of love and attention to our country. Unfortunately, Patricia couldn't take part in this meeting in person because, in addition to her professorship, she is in charge of many other activities. She is now lead researcher, leading the group working on the USA Justice for All project, and she is actually concentrated on the development of judicial system in Ukraine. But we will have her online. The speaker, a person whom I know for very many years, and I'm very pleased to see him with his successes and to emphasize his role for Ukraine. He represents the ECHO, a legal entity. He has been dealing with international arbitration for many years. And the disputes that originally had merely commercial nature now actually reached much higher level where he works with the disputes not just merely commercial level, but including disputes with Russian Federation. And I want to congratulate you with another victory in one of the proceedings against the Russian Federation. Pavlov will make his speech on very complicated matter on how the parties can decide on the in the person of the arbiter. And another participant, Daniel Busevo, founding partner of his company, he has worked for many legal companies which participated in arbitration practice at the international level. So now he's taking very active part in building up and for the development of German arbitration institution. For me, as the one who also worked in development of arbitration institutions, certainly it's a very important speech. If you have any questions, you can write them on the paper and pass them on me, or you'll have an opportunity to ask them at the end of the panel because we first will have presentations of all the speakers and then we'll have the time allocated for discussion. So now could you please?
Дуже дякую.
Hello, I am Patricia Shaughnessy, a professor at Stockholm University and also an expert consultant to the USAID Justice for All activity relating to commercial dispute resolution in Ukraine. It is such an honor to join all of you today as we celebrate Igor Pobirchenko's contributions to arbitration. Thank you to the ICAC for arranging this and inviting me to share some thoughts. I truly wish that I could be with all of you in the beautiful city of Kiev, a city close to my heart. I apologize for having to make this presentation through a recorded video due to scheduling conflicts. I hope that my comments may generate some interesting discussion among the panelists that will follow and with the audience as well. My topic is the best of the best, how arbitral institutions select arbitrators. What is the best of the best, and how can this qualitative standard be determined? There are three key factors that I would like us to consider. First, the arbitrator must be and must appear to be independent and impartial throughout the arbitration. 2, the parties should have trust and confidence in the arbitrator. And 3, the arbitrator should be a good fit for the specific circumstances of the particular case. I will come back to these 3 factors in a few minutes. But let me start by noting why arbitrator selection is so important. The right to appoint an arbitrator is not only an attractive feature of arbitration, but also a key component of the promised and the protected exercise of party autonomy in arbitration. Parties may exercise this right by agreeing to procedures for the appointment of arbitrators, which is typically respected unless such procedures would violate mandatory law, of which there are a few provisions. For example, the UNCITRAL model law provides the arbitrators are free to agree on a procedure of appointing the arbitrator, Article 11, and also are free to agree on the number of arbitrators, Article 10. Most arbitral rules are similar. Party agreements on the appointment of arbitrators may be contained in the arbitration agreement or may have been agreed later. The parties can delegate the appointment of arbitrators to arbitral institutions or to an appointing authority when it is an ad hoc arbitration. By agreeing to arbitral rules of an institution, the parties have exercised their party autonomy to appoint the arbitrators subject to the provisions of the rules. Arbitral institutions typically provide that parties may freely appoint or nominate an arbitrator. Institutions will make the appointment when the parties so request or when it is needed. For example, when a respondent does not respond in the arbitration and does not appoint its arbitrator. Some institutions, such as the ICC, provide that the parties shall nominate their arbitrators, which are then subject to confirmation by the confirming body, typically a court or council or board of the arbitral institution. Such confirmation is typically given unless a party objects and the grounds for the objection is found meritorious. The typical approaches to arbitrators, which arbitral institutions across the globe use, can be classified into about 3 main categories. 1, an open pool of arbitrators who have not been vetted but have their CVs uploaded to an internal or an external database. If it's an internal database, then the institution will use different search methods through its database to try to identify potential arbitrators for a particular case. If it is an external database, then parties may be able to search through that database, which is provided typically on a website. There are institutions, many, that have panels with vetted members. That means that arbitrators may apply to become a member of the arbitral institution's panel, and they need to meet certain requirements and to provide information about their background. Then a body within the institution will determine whether or not to accept them on the panel, and these arbitrators may be selected by parties, but parties may freely choose arbitrators off the panel. In some institutions where there are panels used by the institution when it's appointing, the institution reserves the right to appoint arbitrators off the panel or list when the circumstances would justify that. Another system which is not very common is a closed list, where the arbitral institution has a panel or a list of arbitrators which it has vetted and approved, and requires that parties only may appoint their arbitrators from this list. Turning to the first factor I mentioned earlier about the best arbitrator. Independence and impartiality. We find that this is a requirement that is contained in most legislation, arbitral rules, court decisions, soft law guidance, and practice. The requirement of independence and impartiality is crucial to the integrity of arbitration. In order to ensure this, arbitral institutions, and indeed different regulatory instruments, contain an obligation of prospective arbitrators to disclose circumstances that may give rise to justifiable doubts. This is important to be done at the selection process, but the obligation continues throughout the arbitration. And the reason why disclosure should be made early is to avoid delays and interference and obstruction and problems which may occur later in the arbitration. One of the things to pay attention to regarding this disclosure of different circumstances is whether or not the arbitral institution employs an objective or subjective test. For example, the SEC uses the objective test, circumstances that may give rise to justifiable doubts, whereas the ICC and the IBA use a subjective test in the eyes of the parties. What should the arbitrators disclose? When it comes to disclosure of independence circumstances, when it comes to impartiality, it is an objective test of a reasonable observer. It should be noted that the standards for disclosure and challenge are different. A disclosure of a circumstance does not mean that there is a ground for challenging the prospective arbitrator. Indeed, if the prospective arbitrator considers that the disclosed matter is such a ground, then the prospective arbitrator should decline the appointment. Requests for further details, objections to nominations, and challenge may follow after a disclosure is made. And indeed, that is the right of the parties to have all this information available to them so that they can exercise their right to request additional information, make an objection, or a challenge. Turning to the second factor, the best arbitrator should engender the parties' trust and confidence in the arbitrator to conduct the proceedings in a fair, efficient, and effective manner, and to decide the case based on the agreement of the parties and the applicable law. The third factor is the best arbitrator should be a good fit for the circumstances of the particular case and the needs of the parties. Arbitral institutions have experience with many arbitrators and have many insights into what may be a good fit based upon their experience. But importantly, no one knows the case, particularly at the outset of a dispute, better than the parties. And whose arbitration is this anyway, as Johnny Veeder once asked in an excellent article. The parties may have different approaches to the case, which may make their ideal choice based on different criteria, leading to a different type of arbitrator. This is part of the attractiveness of arbitration. When an institution is making the appointment, they will often look at a number of criteria. For example, one may visit the SEC Arbitration Institute website and can find a list of the criteria which are considered. Typically, these relate to experience, the sector, the applicable law, the parties, and other factors, all which would help to find the best fit. When appointing a chair or a sole arbitrator or an emergency arbitrator, particular regard to case management skills should be considered. Arbitral institutions have been particularly and importantly active in ensuring diversity, which increases the talent pool, enhances the integrity of arbitration, and improves the decision making. The ICAC has been a leader in appointing women, or a sole arbitrator or an emergency arbitrator. Particular regard to case management skills should be considered. Arbitral institutions have been particularly and importantly active in ensuring diversity, which increases the talent pool, enhances the integrity of arbitration, and improves the decision making. The ICAC has been a leader in appointing women. Party appointments across the globe, across institutions, are slowly becoming more diverse, but are far less than the appointments made by arbitral institutions. Diversity is not only a gender issue, but also should take account of geographic, nationalities, backgrounds, race and religion, age, and other factors. Arbitral institutions are helping to bring younger and more diverse arbitrators into the pool. There are many considerations which parties and arbitral institutions consider when appointing arbitrators to get that right fit. My colleagues, who will be now following, will address the selection criteria and what makes an all-star tribunal. Thank you very much.
Від всіх нас, я сподіваюся, ми дуже вдячні Патрісі за те, що вона записала. В мене є питання, Павло, оскільки ти
recording this video, and Pablo, you're here with us. Thank you for being with us. Have you ever had situations in your professional practice where you would recommend to a party to select arbiters through an institution without doing that themselves? Has this ever happened? Do you think that's possible? Thank you for this question. It's a bit provocative, I would say, but I remember a case after procedural codes were amended in Ukraine. And probably all the practicing lawyers remember that most lawyers answering the judge's question would say up to court's discretion. And when the codes were amended, the judge asked, who are you in the process? A lawyer, a defense attorney. If you're a defense attorney, then say what's on your mind. You are paid for that. So if the rules of procedure allow the parties for selecting an arbiter, the counsel lawyers will not be willing to trust that to somebody else, because the counsels are themselves trusted advisors and they have working relations with the client. This is part of the qualified legal aid that the lawyer is providing to their client. It's another story that there are different procedures, different rules, and there are cases when arbitral institutions would help the parties, would provide the list of arbiters, thus narrowing down the options. At the same time, the parties, in order to provide the quality and expertise they wish to receive at international arbitration, they can seek certain qualifications, certain expertise, and even nationality. So this is a joint work. Of course, it's also an effort for an institution to either appoint by default when the rules of procedure say so, or to appoint a chair. So what matters is whether a party has a counsel, an advisor who would take this function upon themselves, as you emphasized, or whether this party is doing that independently. The list could be helpful to identify expertise, professionalism, capacity, knowledge of the rules of procedure of certain arbitration institution that is coming up with this list. So the presence of the list is a good additional opportunity to seek arbitrators. One more thing I have to add, of course, for all of us here, the experience is mostly around ICAC, and they are looking at all of that. They're hearing through the scope of ICAC rules, but I am trying to take a broader look. There's an ocean of arbitration that actually includes ad hoc arbitration. And why am I saying it's easier to select an arbitrator through a closed list? Because the choice is limited. And you know for a fact that each of those arbitrators has experience and can hear a case in a very qualified way. But if there's an unlimited list of arbitrators, then all of those factors that we are going to discuss emerge, because trusting a party or an appointing authority to make a choice of an arbiter instead of you, when you do not understand whether that arbiter is fit for a case, whether they understand how, for example, agricultural products or natural gas is delivered to Ukraine. Well, this actually opens a lot of questions, and a responsible council will not trust anyone to do that. That actually brings us to the topic of your presentation, how this is done. So over to you. Dear colleagues, good afternoon. First of all, I would like to congratulate you on the 100th anniversary of birth of I.Pobirchenko, and I'm grateful to the Armed Forces of Ukraine and ICAC Secretariat for this opportunity to come together at this Colosseum, these walls. It's been long awaited to meet in this hybrid format that we're already used to, with participants both offline and online. And as Tatiana has mentioned, and thank you for the introduction, I have a topic of my presentation which is on one hand is very important, on the other hand it could be very simple for others, but I was asked to give practical advice about selecting the best arbiter for a dispute. I only have 4 pieces of advice. I had only 4 before I entered the Colosseum, and as soon as I took a seat, I remembered another one. There could be more, but I think I only have 10 minutes. Focus on the key ones. And once again, let me remind you that we are amidst the ocean of international arbitration with different rules of procedure. That's a better understanding of the topic I'm going to cover in my presentation. So the first piece of advice, first tip, you need to know the case. Before you select an arbitrator or counsel, you have to analyze all the practical aspects that are relevant for an arbitration procedure. There are a lot of them. And as I've already mentioned, there could be different procedures, rules of procedure, closed list, open list, applicable law, lex arbitri. All of those matters are very important to understand which arbitrator is going to be able to conduct an arbitration proceeding in line with the rules set out in the applicable law and ICAC procedure. Moreover, for an arbiter and the party, what's important is to make sure that the arbitrator that is selected understands the facts of the case and has relevant expertise for working with the case. Sometimes there are cases that do not require sophisticated legal expertise. Sometimes the parties believe that legal matters amount to 20% of complexity of the case, and 80% is about approaches to calculating losses. And this implies completely different roles of arbitrators in such cases. So before moving on to the next stage, it's crucial to understand what the dispute is about. Are there going to be witnesses? What format is the arbitration proceeding going to take? A hybrid? Is there a need for physical presence in the room? Answering all of those questions is crucial for selecting an arbitrator in the case and proceeding with arbitration. Second piece of advice, Patricia Shaughnessy in her presentation was talking about selecting arbitrators. Arbitration institutions, they also strive for the best of the best. And this is actually my second piece of advice. The best is an enemy of the good, and the best is the enemy of appointing the arbitrator that is best suitable for your case. What I mean by that, very often as a counsel, I hear from my clients that they want to see a list of 2 or 3 the best, most in-demand arbitrators to have in their case. And of course, they want us to give them the decisions, publications of the arbitrators. But the best candidate to be appointed by a party in a specific case not necessarily has to be the most experienced, most high-ranking all-star, or the most demanded that the parties most often appoint as arbitrators. Because if a candidate meets the criteria that I mentioned, most probably they will have a high hourly rate that will affect the amount of arbitration expenses. They're going to have a tight schedule because they are in demand, which means they are not going to have a lot of time to focus on the case. And this is not a disadvantage. This is just objective reality. Moreover, some arbitrators, they tend to have preferences. When they already have experience, when they were Supreme Court presidents, in certain jurisdictions, so they have preferences with regards to their role in arbitration, and they might not agree to your appointment because they see themselves as a chair, not a regular arbitrator. And also there's conflict of interest. This is quite complicated for an arbitrator who works with a lot of cases. So my advice would be for a party to focus not so much on hunting the biggest star, but rather engaging an arbitrator who will be able to professionally work with the case, arguments and time-wise. For example, if the party expects a swift resolution of the case, they believe it's very simple. Or, for example, if an expedited procedure is applied, then it's not advisable to engage an arbitrator for whom it is going to take a lot of time. Moreover, arbitrators need to have sufficient time and the capability in line with the applicable law to efficiently resolve the dispute from when it was initiated to the arbitration award. And there's another question, how do you actually do that? And I'm thinking of a joke. A friend comes to his friend, a lawyer. He says, I have a legal problem. And the lawyer says, wait. what are you asking for? Are you asking for advice or consultation? What's the difference? Well, advice is free of charge, consultation is for the money. Then, of course, an advice. My advice is seek consultation. So, my third piece of advice, ask for a consultation or trust your counsel to help you with the selection of the arbitrators if you have counsel.
Well, you need to keep in mind that the party certainly has their interests, say the scope of legal issues when maybe a council even is not required. But there may be quite complicated cases when a party wants to get rid of this legal burden and wants to select an arbiter who fits the best to find a solution to this specific dispute. Advice number 4: be guided with relevant factors to select an arbiter. I mean, do the calibration of an arbiter according to the specifics of your case. Of course, your counsel would know how to do it, but my advice for you as parties or even for councils is that first as the expertise. You need to make sure that your potential arbiter has expert knowledge in the respective sphere of the law. Plus, we sometimes, in addition, let me remind you that sometimes you don't need lawyers, but maybe economists, because there are arbitration institutions where the candidates for arbiters are traders, not lawyers. Second, experience of your candidate with international arbitration, not necessarily as in the role of arbiter, maybe advisor, maybe counsel. He or she needs to have very good understanding about the rules of procedure. So, of course, having any experience is an additional plus, as Patricia said. An arbiter, in particular, member of a panel, needs to understand how to um, manage the case, how you run your team, because arbitration panel is a team, and we as lawyers say that we tend to be introverts. Although I'm not sure, but it's important for the panel members to have very good communication with each other as a team of experts who are considering the same case. Arbitration language is a very important aspect, of course. There are many reasons for that, not only to read the documents and to write the arbitration decision, but it's also important for purposes of communication between the arbiters. The time factor, again, a party wants your service, so they want somebody's services, but you have rules of procedure. And say a case is supposed to be considered within 6 months, and you need to be sure that your potential arbiter has sufficient time to take part in the arbitration session, including time that they need to hear witnesses or victims, whatever. Another point is proficiency, especially in new technologies. Unfortunately, my experience with foreign institution shows that it's rather a requirement for experts, say expert in economic matters, so they use experts review but that expert didn't have a clue on how to operate the modern technologies. And if the arbitration institution uses IT systems, so in order for an expert to take part in hybrid format, you need to keep that in mind. Reputation, of course, very important factor, which needs to be considered. Cost of services, of course, many arbitration institutions have certain limits set for fees, but there may be ad hoc arbitration hearings where the limits may be set according to the hourly rate of arbiters. So if you want the best of the best star of the constellation, the party needs to understand the cost. I'll tell you that similar experience, which is rather relevant for the pre-hybrid format, which became normal for our institution. This experience was very important for appointing, say, foreign arbiters, say, from the United States. But when this arbiter informed about the cost of the services, the party could change their mind quite easily. It's very important to know in advance because after the arbiter has been appointed, it's very hard to change because if you require the change, you just shoot your legs because you delay the proceedings. And one more point about the conflict of interest. Of course, um, rules of procedure and laws often mention that point, and according to Ukrainian legislation, it's a duty of an arbiter to check for absence of conflict of interest. But I believe that the council's role also is to make at least the first step. Maybe there is an explicit conflict of interest. At least then you avoid disappointment and hence then the arbitration institution will not have any debts with regard to impartiality of your appointee. Fifth advice that I added today is this. The translation is Plato is my friend, but the truth is worth more, is more important. That means that the client may have a friendly relationship with potential appointee, or you as a counsel are a friend with a potential arbiter. But here, first, there is a question about the conflict of interest, and I know often my younger colleagues appoint an arbiter or agree on an arbiter, and then they find out that they didn't check the circumstances. You actually lose the case, or at least give an opportunity to challenge the final decision. So, how do we deal with these circumstances? All of them are important. How can you find out answers to these questions? So, if you are talking about education and experience, of course, a good counsel should already have kind of a list of potential candidates. If you have worked for years in this business, then you're aware of arbitrators who may already know the answers with regard to candidates. Or a party may just read this potential arbiter CV, publications, professional comments delivered, experienced counsel normally tend to check all this very meticulously because another party may use standing of an arbiter in the case, standing which was presented earlier. Also, there are cases that have made public promulgated. Then you can read about the cases you can use to work before. Plus, the information market is quite fun, so you. And another point is kind of an interview with a potential auditor. There are different approaches to this interview. Maybe later on we'll look at it in more detail. But some rules of procedure directly uh, indicate that such interview is possible. Even more than that, guidelines of International Bar Association with regard to representation of a party with the international arbitration contains direct provision stated that that's absolutely admissible, of course, with certain limits. To conduct such interviews. Some other rules of procedure do not regulate that. The practice may be so that an arbiter doesn't want to, the council doesn't want to conduct such interviews. Everything depends on the circumstances of the case. So, to conclude, please keep in mind that there are many factors. We could this whole conference to this matter. But keep in mind that the best arbiter is not somebody defined by a rating agency, but the one who fits the best the specifics of your case. And actually, under different circumstances, the three parties may have different preferences with regard to the arbiter of their choice. I'll get back to my seat. Thank you indeed. Now we can get in touch with Daniel. His presentation, then we'll have some more questions. But I think
See you with us, and we are really glad that you managed to join us. Everything is okay. We are ready, and we are listening to what is your view on this small but strong group of people, which is named Arbitral Tribunal. How they cooperate, how they communicate, and what can be the result of the lack of communication and cooperation. So everything you want to tell us, you are welcome.
Good afternoon. I think that was an introduction to myself. I'm not entirely sure because I heard only part of it. I think the interpreter overran a bit, and therefore I can only guess that it's my turn now. But I'm very happy, if it is my turn, to address you on the subject that has been assigned to me, which is a team of stars or a star team, what makes an effective arbitral tribunal. Ladies and gentlemen, if you buy a house or an apartment, your broker will probably tell you that there's three factors that you should first and foremost consider. And that is location, location, and location. In a very similar vein, if you are to engage in an arbitration, you will have three very important factors that are more important than everything else. And those are arbitrator, arbitrator, and arbitrator, which I believe makes even more sense because there typically are three of them on the tribunal. But it's not only about the three arbitrators individually, which I think my colleagues have spoken about very aptly, but it's the combination of them. And depending on your role in the arbitration is different if you are a counsel as opposed to a fellow arbitrator. You will want to make sure that the combination of the three arbitrators works. So ideally, an efficient tribunal will be more than the sum of its individual parts. I've sat in more than 100 cases as arbitrator, and yet at the same time I've acted as counsel in more than that. So I think I can contribute that double perspective, which might help shed a bit of light as to the cooperation between the members of the tribunal and a good appointment of them in the first place. And as I said before, I'm not so much concerned with the qualities of an individual arbitrator. I'm more concerned with finding the right combination. And what the right combination is, again, will differ with respect to what role you have. If you are a counsel, you obviously want to make sure that the tribunal as a whole works efficiently, but at the same time that your client's position is communicated very clearly and ideally prevails within the arbitral tribunal. So what do you want to do? Or perhaps even better, what do you want to avoid? What you want to do is you want to appoint someone who's closer to the chair than the appointee of the other side. And for that, obviously, to be done, you want to make sure you understand what the potential chair would be like, either because you can agree with the other side or because you get a feel for the institution and their potential list of suitable candidates. So what you want to avoid is appointing someone that likes your position, but will end up to be isolated on the tribunal. So I call that, I don't know whether you have my skeleton of the presentation, I call that game theory and practice. And my advice is don't appoint the outsider. And let me illustrate what I mean with that in two examples. One example is a case where there was a jurisdictional outsider. I was counsel and I represented a European party, and my opponent was an American company represented by an American attorney or law firm. And that law firm appointed an American co-arbitrator. I knew quite well, knowing the ICC as it was at the time and the people making that appointment, or at least bringing it about, that very likely we would have a European chair. So I appointed a European as well. And that ended up making sure that the two arbitrators that I had appointed in the chair were working quite closely together, whereas the American was on the sidelines. And that ended up winning me the case. Not only that, obviously, we had a strong case and a good team, but it helped tremendously to have an arbitrator appointed that was closer to the minds and the background of the chair than the appointee by the other side. The second example is a generational one. It is a case which I did as a co-arbitrator when I was much younger than today. And the other co-arbitrator was a grand seigneur. He was 30 years my senior, and he believed that he had all the gravitas in the world and would certainly dominate a more junior chair. So he agreed with me on a junior chair, and that chair was approximately my age. It was at least my generation. And it turned out to be very different from what the esteemed colleague on the other side was expecting. Not only did he not dominate the chair, but rather the chair and I hit it off quite nicely because we were of the same generation and had a very similar background. So my point is, to sum up that particular line of thinking, you do not want to appoint someone who will likely turn out to be an outsider on the tribunal, even if you think that that particular appointee will be very sympathetic to your ideas, to your positions, and to your own background. Now, let's switch perspective a bit and look at the situation that you have when you are a co-arbitrator and you want to appoint the chair. There's one particular piece of advice that I would like to give you that is not often adhered to, and it's something I think you should follow if you want an efficient tribunal. and that is prioritize procedural competence over specific experience. Now, what do I mean with that? I mean that it's not the most important thing for a chair to be knowledgeable in the applicable law or in the industry. Yes, it is helpful if the chair has experience with the relevant industry, and it might help if he or she has knowledge or is even trained in the law that applies to the dispute. But oftentimes I see that candidates are chosen not because they are good chairs or because they will probably harmonize very well with the co-arbitrators, but because they have a particular set of parameters, a set of characteristics. So my point is, if you are faced with a choice where you have a strong arbitrator or someone from a particular background, choose the strong arbitrator. A third perspective I'm well prepared to speak about is the one of the institution. And I say that because I've never worked actually in an institution, but obviously I've been on the receiving end of institutional appointments more often than I would like. So I've seen a number of institutional appointments that I did not particularly like, and there's a number of factors for that. I understand that institutions sometimes want to appoint more junior lawyers because they want to give them their first chance, or they're all up for diversity considerations, and I think that's all very helpful. But at the same time, sometimes an institution ought to think more about the parties and the harmony with the co-arbitrators than finding the right person they think is in line for the next appointment. As I said, I will not expand further on that because it's not my primary perspective, but I think I just say that because I've seen it a few times. And if there are members of the audience who work in institutions or have connections there, it might still be a remark worth making. Now, you will have seen that in my outline, there were 4 sections. One section was on the composition, that is what we just covered. Composition of the tribunal, I mean. The second section is about the cooperation between the members of the arbitral tribunal. So how does an arbitral tribunal work? And it sometimes works very differently from what a council thinks it does. And therefore, I think it's very important if you choose your counsel to choose someone who has sat often on tribunals, because that perspective is invaluable to the service as a counsel. There's a large number of issues that I could address with respect to how tribunals work internally, but there's perhaps one thing I would like to leave you with, because it also informs your decision if you are counsel or party as to who to pick as an arbitrator. And that is the style of deliberations. I see it fairly often when I sit within an arbitral tribunal that deliberations are structured top down rather than bottom up. And with that, I mean that sometimes chairs feel that they run the show and they have the co-arbitrators just as sidekicks for approval of their own proposals and drafts. And that's not something you want, because the more three-dimensional deliberations are, and I know there is no comparative three-dimensional, but you know what I mean. The more lively, the more helpful, the more efficient the deliberation is, the better it is for the overall result. And the more often the position of the parties that you have appointed or that you are representing is on the tribunal. So what do you want to do? You want to appoint someone who is very well able and open to letting the co-arbitrators play an important role. And I hope I'm not stepping on anyone's toes if I say that sometimes professors and judges are not the ideal chairs, because they are used to working alone. I know there are exceptions to the rules, and I've sat with excellent professors serving as chairs. But sometimes you don't have an ideal combination if you have someone who is, as I said, used to doing things as they see fit, rather than being able and prepared to consult with their co-arbitrators and to find a solution that is geared at making sure that everyone is heard and that all the positions are properly reflected in the eventual award. There's a few issues that one might ask, for example, how wise is it for tribunals to appoint someone for particular parts of the dispute? Should they be specializing, if that's the right word, in certain aspects of the case, or should they even take parts of the drafting responsibilities? But I think that has perhaps too much to do with the internal deliberations and is not so much visible. So I might as well just hint at it, but not expand on it further. But if you're interested, I understand we have a discussion. I'm very happy to speak more about that if you feel like it. The third section of my presentation deals with the phenotypes of arbitrators. So which phenotype of arbitrator is helpful, perhaps not so helpful, if you want an efficient tribunal? And if you've seen the outline, you will have seen that there's three particular phenotypes that I don't find very helpful for an efficient tribunal, and if you consider appointing them for making sure that your position is heard in the deliberations. The one type of arbitrator that I don't think is a good idea to appoint is that gun. And in particular, inexperienced counsel and parties sometimes think it's good to have someone who we know from reputation and from experience will push very strongly for the position of that party. And what I can say is that if that happens, more likely than not, that particular hired gun arbitrator will become isolated in the tribunal. And he or she will achieve the opposite of what you want it to achieve, him or her to achieve. That is having clout in the deliberations, having a real impact within the arbitral tribunal. So you want to make sure you find someone who is very good at understanding your position, but just at the right strength and not too hard. I've said just the other week in Switzerland with a very well-renowned Swiss chair, and she said to me, I disregard anything that such a person says. At least I'm listening politely, but as far as positions are concerned, I'm more likely to form my own position than leaning on to what I hear from a hired gun co-arbitrator. The second phenotype that I would rather advise against is the lonely wolf. And that, in a way, circles back to what I said earlier in the section on the composition. You don't want someone who's very good at what they do, who have a very good reputation as a lawyer, but who's not very good at cooperating. Or put it perhaps succinctly, emotional intelligence sometimes is more important than knowledge as a lawyer. The more you are as a co-arbitrator in particular to latch on to the and think in a tribunal and to make sure you build a good rapport, the more likely it is that the position of the party that has appointed you will be given consideration and will be adopted eventually. A third type of arbitrator will be appointed, but normally without being really effective, is the specialist. And that refers to someone who's extremely good at a particular case, but not an overall efficient arbitrator. Sometimes that goes so far as to have a non-lawyer being appointed, but someone who's an expert in a particular industry or a particular subset of facts. Sometimes it goes, but people are chosen for their expertise with a legal system or with a particular question of law. And more likely than not, that's not going to be very effective, because you normally buy that that strength by also acquiring the weaknesses on other parts of that set of skills of that particular arbitrator. So those are the three types of arbitrators that I would not advise, and I hope that gives you, together with the sections on the composition and the cooperation amongst the members of the tribunal, a good overview of what it takes to form a good tribunal. And obviously, as a counsel or as the party instructing your counsel, you can only influence a part of the tribunal. You can in most cases you can influence one of the arbitrators, and you can play a part in appointing the second or the third, depending on how you count. But you cannot influence the whole tribunal. But still, within those limits, it's extremely important for you to make sure that you pick the right arbitrator. I sometimes see that arbitrators are appointed on the basis of personal connections or on the basis of hearsay. It is probably the most important decision that you make as a counsel or as a party in a tribunal, or in an arbitration rather, and therefore it is absolutely justified to spend a great amount of time and effort in choosing your arbitrator, because if you choose them wisely, you increase your chances of success in an arbitration. And that closes my presentation. Thank you very much. I cannot hear you. I don't know if that is a translation issue or whether there's a technical point.
Do you hear me now? It's okay? Yeah, good.
Now
Thank you very
you.
much. Thank you very much. I would like maybe to use, we have 15 minutes to use them for questions, because many things being addressed by Pavlo and you, they have something common. And I have already two questions from Sergei Grishko, who raised a very interesting issue connected as well with what Pavlo said at the end of his presentation, how a person can get knowledge about the qualities of the potential arbitrator. And Pavlo mentioned that one of the possibilities is to have the interview with the person. And I'm just interested about your attitude to this tool, whether it is like a well done possibility, or it is something that could be misleading or dangerous even for your internal decision. So I address this question both to you, and maybe Pavlo, you to start, and Daniel to make your comment after.
Thanks. Yeah, definitely different approaches are used by counsel in interviewing. As I mentioned, it seems to be absolutely appropriate tool. Like a short answer to the question is, I don't believe that you would know any quality, human quality or expert quality of the arbitrator from the interview. And for the one simple reason. During the interview, the scope of the questions that you may ask the potential arbitrator is limited. And limited to, I would not perhaps say list all these questions you may ask, but first, willingness to be appointed, availability. As I mentioned, time is of essence for the party, so the arbitrator should confirm conflict of interest. Perhaps there may be some other questions, but you will never know the quality of the arbitrator. In that respect, I guess if I will proceed, may proceed on the how to know the quality, except for the personal experience with a potential candidate, is I just recall when Daniel mentioned several cases. I just recall one of my cases in investment arbitration when, before we advised the client in respect of potential arbitrator, we already reviewed a huge pile of documents and awards, dissenting opinions of potential candidates, and found several who were perfect. They participated in almost all investment disputes, which we rely on in our case. So we appointed one, and then the state decided to appoint, as usually, not about the quality, but about the characteristic, the pro-state so-called arbitrator. But it appeared that that arbitrator participated almost in all our cases that we used in our submissions to support our case, but in different, I guess, as an expert, sometimes as an arbitrator or as a counsel, but nevertheless. And this ended up that they both appointed also an arbitrator somehow relevant to these cases as well. So it was then easy for us actually to operate with these decisions and the practice, since it took a little time for us to explain our position. That's how perhaps you can know the quality, but definitely the arbitrator is not an open book, I would say, yeah? And you can find many secrets later on. Thanks. Yes, sure.
Dear Daniel, what about you?
Let me answer both of your questions. I think you basically asked two questions. How can I understand about the qualities of a particular arbitrator, and how useful or dangerous are interviews with arbitrators?
Yes.
I'll take them in reverse order. On the interviews, I don't think they are dangerous if certain guidelines are followed. And those who do this regularly know that there is a set of rules that is contained in a soft law element, which is called the CUP guidelines. And they are universally, I think, accepted principles that if you adhere to them, if you follow the rules therein, you are safe. You would not compromise your arbitrator, and there should not be an issue. Are interviews helpful? I think I'm a bit more optimistic that they are. I've sat in interviews with potential arbitrators where I've found that the differences were quite huge. For example, in one interview, I heard the arbitrator talk a lot about the target. It was a post-M&A dispute, and it was about the target of that transaction and about my client. And it was clear from the answers that he gave that he had done research prior to the interview and had made sure he understood everything there was to be understood about that particular party and about the case as far as it was published. And obviously that was very helpful because it showed there was an eagerness to really put in the work to do what's necessary to make a good impression in the tribunal and to influence the case in the right direction. So obviously, if it's half an hour, 45 minutes, you don't learn that much, but you do learn certain things. And sometimes it's not so much what they say, but how they say it. As regards the question of what you can learn about an arbitrator before you appoint them, obviously there are numerous sources. There's databases, there's statistics, there's publications, and a good shortlist that is prepared by counsel will have done and will have implemented a lot of research on such tools. But what's, I think, even more valuable than that is the personal knowledge of people who have sat with the candidate. And it is also for that reason that I enjoy sitting as arbitrator so much, because you do see how arbitrators actually operate. And I think all of us who have sat as arbitrators will know candidates or will know arbitrators who have a great reputation, but they have not read the file. And sometimes I'd strongly advise against appointing a big name, even though they're still in the ranks fairly high up, because I know that they will not put in the time that's necessary to understand the case and to read all the exhibits and to make sure that they can really play a part in the deliberations rather than just nodding along when the chair says something. So I think that is a tool that I would like to highlight. And if you choose your counsel wisely, then I think they can help you with getting an inside view of the candidate. And I think that is tremendously valuable.
Thank you. We still have time. Any questions from the audience? If not, I have one. So you mentioned these short lists. Whether you consider them to be helpful when the parties are engaged in this play with the short listing, then deleting, ranking, etc., and whether you have some advices how to deal with this practice. Daniel, maybe for you to start.
I think shortlists are being used in two different sets of circumstances. The one set of circumstances is the situation when you talk as counsel with your party. And that's actually what I was referring to. Obviously, there is also a list system, or there are tools to employ when co-arbitrators speak with each other, or sometimes the parties speak with each other in the process of finding a chair. But that's not what I meant. What I meant is the work that's being done between the counsel and the party in the process of identifying, in particular, the right co-arbitrator, but later on also the chair. And I'm always skeptical if a counsel says, I know precisely whom to appoint, this is the right person, there's no one else that we should consider. I think it's fair to the party that you represent as counsel to give them the choice. You can guide them, but I think they should have a choice. And because there is rarely the right arbitrator. There's candidates, some of them are stronger in certain aspects, some of them are strong in others. And I think it's for the party to make the eventual decision, obviously guided and assisted by you as counsel. And in that process, I think these shortlists are very helpful, also because they force you to do the work that I think is extremely important, to go through the databases and to do everything that's needed in order to make sure that you come as close as knowing everything about that arbitrator or those candidates that you can.
Thank you. Pav.
Yeah, I tend to agree with Daniel. I would also add perhaps that this is very efficient, maybe an efficient tool as well, since you provide your client with an opportunity to run their internal conflict check before, basically, as I mentioned, that's the duty of counsel to review a potential conflict of interest before even approaching an arbitrator. So that's how usually, if you provide a short list, 3 to 5 potential arbitrators, your client confirm, then you can start, definitely you have some priority, and then you can start approaching arbitrators. Some of them may say that they are not free to act as an arbitrator, and you will save your time and the clients as well. And you, since as Daniel mentioned, and I also agree that there is a huge time spent by associates, partners on selection, like reviewing all the available information in respect of the arbitrator, as well as opposing, if you are respondent, so you know already who is claimant appointed party arbitrator. So definitely that all plays certain role, very important role. Thank you.
Thank you very much. Actually, we exhausted our time, and if any brief comments from the audience, yes, please, Yaroslav.
Hello, everyone. Hello, everyone. My name is Yaroslav Grigirchak. A quick question to both Paulo and Daniel. in the development of what you guys mentioned in terms of different setups that can take place at that stage when arbitrators are being appointed and they do cooperate, everyone or a certain part. I mean, ultimately, this all has to end up with a certain arbitration award. How, what are the features of a good arbitration award which reflect the fact that the tribunal has been diligently and properly attending to the merits, apart from timing? Or there is a certain number of arbitrators on the panel that have been cooperating, and even though, right, the decision might not necessarily is friendly to everyone involved, there is a party losing, but nonetheless, they did the good job not only on the merits of the claims made by the party that won, but also they have satisfied the curiosity, so to say, and the money paid by those that lost. Thank you.
Who would like to start? Daniel, can you?
I can, of course. Obviously, what an award should look like is an entirely separate subject, and it perhaps even justifies a new inference. But I think basically the answer is in the question. It is important for an award to make sure that the tribunal demonstrates to the parties that they have heard all the main arguments and they've understood them and that they've considered them. And sometimes I see arbitrators, in particular arbitrators who normally work as judges, to be quite dismissive. They want to understandably base their decision on a number of pillars. So they say for that reason, the claim does not go in, for that reason, doesn't go through, for that reason. Sometimes that is formulated in a way that is quite harsh. And I like to read awards that make sure that the arbitral tribunal has really deliberated, has really understood that there was a good situation in my example now, a good reason in my example to bring the case in the first place. That the council and the party understand that yes, they did lose, but that it was a case worth bringing, and that helps also to make sure that arbitration as an instrument overall is cherished and is chosen. Because if you are too dismissive with the claims, then that can in extreme cases give rise to a challenge of the award, but it can reduce the attractiveness of arbitration. So that will be my answer.
Thank you. Pavlo, you have 1 minute for your comment.
Yeah, 1 minute for a very complex, actually, question. Thank you, Yaroslav. But my brief answer, I believe that such an award should first comply with the procedural rules and lex arbitri, cover all the requirements set forth by these two arbitral rules and lex arbitri. Second, as Daniel mentioned, it should cover all the issues in dispute principle and provide perfectly sufficient grounds explaining which a party would understand and a court at the place of arbitration would understand. And third, this award should be enforceable. So arbitrators, when drafting an award, should think about that the award should not be subject to setting aside, should not provide for grounds to be set aside at the end, and should be enforceable. That's brief.
Thank you very much. And again, I thank to all our speakers, and I will invite Nikolai Fedosovich to substitute me for further actions. Thank you.
Ви дозволите мені зробити коментар і оцінку. Ну, як учасник конференції. Я можу, так? Да, я говорю, що я...
I'd like to comment, give my feedback as a conference participant. Tatiana, Neil, all of those
and very interesting, especially, Pavlo, when you address specific issues, and Daniel's insight about psychology, all of that is very important. And what I would like to say, Danielle gave two examples, and negative examples when arbitration institution would appoint arbitrators, and he didn't like it. And as a head of arbitration institution, I was wondering, and that's a question to you both, what is the best way to select and appoint arbitrators? There's a working group that has been working and thinking about what's its best. Is it a closed list, open list, arbitral institution? So what is the best way to select and appoint arbitrators? I'm sorry for delaying. Daniel, since you were speaking, maybe you could take this question.
I'm very happy to. I'm not sure there is an easy answer to that question. It's a very complex question, and I personally am not so much a fan of a list system, but it has its advantages. I'm just not sure how much it really helps to streamline the number of candidates. I think my answer would be a very soft one. I think the better you know certain candidates from experience, from people who have sat with them, the better it is. As I said, reputation is one thing, but the time that people have to really work on matters and the diligence with which they actually discharge their duties as arbitrator, that's much more important, I think, than credentials. And therefore, I think the more one can invest in finding out how certain candidates are really doing in practice, the better. I know the ICC has a system where certain information is stored internally to how things went, how quickly what, for example, was delivered after the hearing, and all these things. So that's certainly something that's valuable, because it does involve real life experience and recent experience with candidates. I hope that at least partly a question.
Я продовжу.
I'd like to continue before I forget. First of all, I would like to thank interpreters and to say sorry, because I remembered that there's simultaneous interpretation, and I realized that the speed that I was talking with, it was quite hard. So thank you. So Mykola Fedosovich raised a very acute question, and it was a very nice way to put it. And there are several dimensions: closed and open lists. That's one thing, because it doesn't end there with closed and open lists. To tell you the truth, a closed list has its advantages, and there's the sum in dispute, the type of dispute, and certain institutions, not only ICAC, they uh, limit the list of arbiters with certain purpose. It's not because they want to limit the parties in selecting arbitrators, but because they want to make sure there's impartiality, independence, competence, etc. So they want to make it easier. At the same time, they want to make sure that when the parties appoint arbitrators in line, it is in line with the expenses and fees according to the rules, because sometimes the parties would appoint arbitrators, but then later they are not willing to pay the fees. And once again, let me emphasize that the best of the best, the stars, they cannot take part in all of the proceedings. Well, time is money, and there's this dilemma, the rate. So there's no such thing as a perfect option. But whether it's closed list or open list, arbitral institution, um, which is expected, will appoint arbitrators by default, or appoint a chair, and but these functions are performed with high quality. And I actually used a phrase, acute, painful question, because in two institutions, not IPAC, uh, appointing arbitrators and chair by an arbitral institution took a lot of time, and we had to seek recusal because the arbitral institution did not do their job properly in vetting impartiality and independence. Um, it took us a lot of effort to undo it. So the council has responsibility in looking into candidates, and the same goes for the arbitral institution. They need to be meticulous, just as the council is. The arbitral institution needs to do their job properly. Well, you're overestimating the role of councils. You think they're all geniuses, very so talented, and the institutions are doing it wrong. Um, well, that brings me back to what Daniel was saying. You need to have councils, good councils, because otherwise it would be very hard to win. And one more thing. I'm so sorry for intervening. We're going to go on a brief break after this. As my analysis has shown, the most recent trend, and it's actually very obvious, is that the parties are left without the right to appoint an arbitrator. And there's this concept of nomination of an arbitrator by a party is introduced. And the new rules of recognized institutions like HKIAC has an article which says that the president appoints an arbitrator without providing reasoning. There's uh, as one famous arbitrator used to say, it's not arbitration, it's something else. Because one of the principles of arbitration is a party's right to select an arbitrator, not an arbitral institution. So, where do you find uh, that best option? Should it be um, a symbiosis, the better of two worlds, combining with arbitral institutions and their vetting? And ICC was mentioned on more than one occasion. ICC that actually focuses a lot on that. So there are pros and cons. And once again, going back to the presentations of our speakers, um, your insightful presentations actually inspire me to think about this further. So thank you, Tatiana, for moderating this session. Thank you for helping us to come up with certain ideas, certain considerations. So as organizers, we would like to thank Daniel, Pavlo, and Tatiana for uh, so much joy. Uh, and now it's time for a break. No? Thank you for your participation. And please do not leave 20 minutes. 20 minutes break. Oh, okay. Uh, no break. We are going to have a special presentation. I will give the floor to those who will speak about the great uh, I.Pobirchenko. Uh, he is renowned expert. And we have Lyudmila Fedorivna, a long-standing deputy head of ICAC, and she was in the first recommended list of arbitrators, and she has extensive experience of teaching at Kyiv Shevchenko National University. Our second speaker uh, joined arbitration. Sorry, Tatiana, um, became the deputy head of arbitration, but then she went back to being an arbitrator.
A big friend of Ukraine, our friend from Serbia, Professor Alexander Chiric, who, as far as I can remember, he had studied since the 90s. I don't want to offend Alexander. He, as far as I can remember, was really mentoring Chiric, and they both followed the same path, I believe. But certainly Professor I.Pobirchenko took the leading role, while the Professor Chirit certainly was rather the follower. So I will now switch to Russian just for 7 minutes because Alexander still has some needs a little bit more of Ukrainian. But first, I'll offer the floor to Tatiana. I don't know what she's going to talk about. But my request is that you speak about academician Pobirchenko. Maybe I will switch to Russian too so that Alexander understands us. Any objections? No objections. See, Alexander, how much respect you enjoy here since 1972. They knew each other. Uh, it's a very long way, so I'm switching to the Russian language. Since nobody objected. So Igor Gavrilovich Pobirchenko was so unique individual that you would remember him from the first time you saw him. Unfortunately, I was not his student because I studied at Tel Aviv State University, but I remember very well a day when I saw him for the first time. It was very quick. Meeting, I was agency arbiter with the Ukrainian institution. He used to be the head of some department of commercial law at the university, and he just drove by our legal department to find out legal act. So my boss introduced him to us. And he was, he entered the room all friendly, all shining, very nice, very charming. That lasted for maybe a minute or maybe 5 minutes, but I remember that for the rest of my life. Second time I met him much later when there was ICAC in place. At that time I was a counsel and I represented interests of my clients. He liked my style of work, my approach, and in 1997, he suggested me to become ICAC arbiter. Of course, that was a big honor for me. Plus, I was very proud with the fact that at that time I was the first counsel included into the recommended list of arbiters. And Pobirchenko liked to stress that. Yes, at that time, of course. At that point of time, sure. So I believe that Mr. Pobirchenko was my teacher, very serious teacher. He taught not only the law, not only the case law, he taught how to approach life. This his love for life, his great friendliness. You could always come to see him to get his advice, and he would go beyond even the boundaries of this advice, and he would switch the conversation into mere human dimension. He would remember some episodes from his life, especially about the cases he had to investigate many years ago, and what I was impressed with. He remembered all the circumstances of the case, the legal standing applied. He could tell you the parties, and he'd tell you names and patronymics and the last names of the representatives. And knowing this peculiarity, we who worked with him, yes, his alumni, yeah, they were also his employees, etc. So we made a suggestion to him to honor his 80 years anniversary. We suggested him publishing a book, his memories. Initially, he kind of opposed this idea, then he thought and agreed. And he was so much engaged into the work of this on this book. And by his 80th birthday, the book was there. By the way, this book is still available at ICAC. I think it is available on our website. At least we consider this issue to post it. There are many pictures of him, many memories. Its book title is Memories, Documents, and Thoughts. And instead of preface, he wrote the following. After having passed a long life path, an individual needs to look back to recall cases where he devoted all his forces and capabilities to recall those whom he was working with all this past. And last he writes, all my life is linked to fight for fairness, and that's what my book is about. When I was young, there was a war which actually formed and shaped out my character. I'm satisfied with my destiny. It's a happy destiny. I think these words depict in full Mr. Pobirchenko. He really loved and liked life, and life liked him. Whatever position he was in, he always was successful, recognized, and respected. You all know that he was the first chair of the Commercial Arbitration Court with the Chamber of Commerce of Ukraine, and he held that position for 18 years. I don't want to speak too much about that. So I'd like to just mention some points that maybe are not known to many of us. First of all, he went through the war, was a veteran of war. He was 17 years old, the war started, and he volunteered and until the very end of the war, till May 1945, he served with the tank troops, and he was very proud of the fact that his tank was the first to get into Oswiecim when this concentration camp was liberated. He was very proud of that. Maybe some of you do not know that he devoted 28 years of his life to the University, he created for the first time in the USSR the sub-department of commercial law, and he was head of that sub-department. Maybe some of you do not know he wrote 240 scientific papers, including 11 monographies. I was really surprised when I learned that many of his papers were translated into a number of languages, including Slovenia, Switzerland, France, and many other countries. Unfortunately, life is not eternal, and well, he is not with us anymore. But all his light image, all his love for life, all his charm will be remembered always, and we certainly are thankful to him for this path that we uh, took together. Well, to know more about a human, an individual, you need to know about the individual sources. As Tanya said, yes, he was a fighter. He was a veteran, and all veterans have this quality. I'm comparing with my father. He is just 1 year younger. And so he also volunteered. So this is crystal honesty and very principle-based approach to fight unfairness. He hated situations where an individual would make something unfair, or more than that, dishonest. So in my office, I have his portrait. He could give a characteristic to an individual, and the worst was that this characteristic would fully match uh, the individual's actions. So this front line probably gave him those qualities that would make him fight, and that's why we call him the Knight of Fairness. This is the key quality of that individual. Ludmila, please, the floor is yours. Dear colleagues, I will switch to Ukrainian. I hope Mr. Chirich will understand me. But just to continue what previous speaker said, Tatiana indeed gave a very warm picture of the professor mentioned his participation in the Second World War. As you know, he liked his co-veterans, and since my father also used to be the veteran of that war, also from the tank troops, they were very connected with each other. And that's separate part of his life, and I'm very thankful for giving, for mentioning these parts of his life. But I'd like to draw your attention to some other important features of the life of the Professor Pobirchenko. I would recall some cases which demonstrate his internal feeling of fairness, where he was trying to fight any unfairness. I like the wording that I found. I was thinking, what should I mention here? An American writer wrote that a great teacher inspires you. And indeed, he inspired us to many things in my personal life. He played a decisive role without any exaggeration because I believe that the fact that I realized myself as a teacher, professor, researcher, and lawyer, of course, he played a very important role. But let me remind you about how our arbitration was that so that you understand the circumstances when this work was done. The Soviet Union decomposed the first law on foreign economic activities was passed. The commercial courts that had been arbitration courts before were established. Still, many competencies were left to just regular trial courts. There were many disputes about judicial control over the execution, many disputes about the procedure to challenge any decision delivered by foreign courts, etc. So that was a large scope of work that had to be done to provide multifaceted support to proper legal base, the legal foundation of operations and activities of ICAC in Ukraine. We remember all those seminars, conferences, discussions, meetings with parliament members, members of parliament, active participation of judges, arbiters in all these activities. So we understood that we were working on the same legal field and all that worked. We managed to engage outstanding persons, outstanding lawyers and justices, and all that was thanks to the very high reputation that Professor had in the scientific community. And that's very right thing to invite Mr. Chirich to speak here because Professor was known not only in the USA but also in many European countries. So when the ICAC was established, yes, he established really good relations with his friends abroad. Professor I.Pobirchenko was very proud of the first resolution of plenary session of the Supreme Court. In 1999, there was no relevant Ukrainian legislation on execution of arbitration awards. It was the first resolution related to arbitration awards. Besides, I'd like to recall some very practical situations in life of our court. Our esteemed lawyers might not remember that. Although now there is a different law on hard currency. I remember the first law on settlements in hard currency, which included huge violation of our business entities. There were some deadlines for crediting hard currency on the account for using it, etc. Many limitations and restrictions. So, in fact, state tax authority could apply fines even if the debt was repaid by a non-resident by the time of judicial review. That was nonsense, but they interpreted the law very formally, thus applied all those fines which really caused the feeling of unfairness. So Professor gathered a meeting of arbitration arbiters, so and there was decision on what's the right way to work out any awards, how to establish the fact that the debts were repaid and redeemed, but still the state courts followed these trends established by the tax administration, tax service. Professor had a number of meetings with people's deputies, with the head of tax authority, and he was insisting on removing the shortcomings in the legislation. So they were not removed very quickly, but the case law of arbitration started moving towards more fair awards. And just to conclude, I'd like to remember another example. First, we started working with Ukrainian post office, and we started receiving from them confirmation of the service of documents. But they would never mention the reasons why certain documents were not served. And I remember the professor created a team where I was part of it to really process big number of correspondence to make analysis, and we presented all these examples and analysis to the leadership of Ukrainian Post Service to show how much impact that causes to our activities. And Professor always try to apply as many efforts as possible to make sure that everyone is doing his or her job properly. And I remember I had this discussion with him. I told him, "You are not a boss, you're a researcher, you're a scientist. You always push us towards discussing the law, case law of the courts, but it was very positive. We could really express our thoughts. Forgetting that he was our boss. I'm very thankful to Mikola Fedusevich for following this approach. It's very important. We continue these creative discussions now. They even are escalated to the level of presidium. Uh, and thus we are trying to find a way out of any situation together. I'll conclude by saying that yes, ICAC is improving for all these 30 years. We want it to be better to meet the first international traditions of arbitration. Although, as Tatiana Stepanchuk said, not one of the conferences used to be young arbitration, but now we have quite progressive arbitration legislation. We developed more or less adequate case law with the right approaches, and Nicola made the right statements that any violation of international agreement is about violation of the duties of Ukraine. So certainly we are building our future together, which will be the best monument to our teacher, Professor Pobirchenko. Thank you, Ludmila. You just made us recall another uh, part and peculiarity of his activities, but I'd like to now to invite Dr. Alexander Chirish to the floor. Please, what could you tell us about our leader and teacher? Thank you, esteemed chair, dear colleagues, ladies and gentlemen, good afternoon. I'm very thankful to my dear co-authors of our co-presentation Night of Fairness, Tatiana Zakharchenko, Lydia, for their great contribution and speeches that allow me, with all respect and honor, to share with you just some examples of this night spirit activities of Mr. Pobirchenko. First of all, yes, the fairness is a kind of his credo. He wrote, "All my life is about fighting for fairness." That's what he wrote in his autobiography that he devoted to his mother. Second point, fairness of Pobirchenko is an inseparable part of his education, his scientific work, of his academic activities, interpretation, and application of the law in arbitration practices. At his lectures on arbitration law, uh, when I was a postgraduate student, I was translating his lectures at the International University. The students asked him how did he manage to give this analysis of very complicated legal issues. And his answer was, the aim of the law is fairness, objectivity, and professionalism. It's much easier to understand the life as it is through the eyeglasses of fairness. Third point, fairness, Mr. Pobirchenko, is, according to ancient Rome slogan, that the law is the art of good and fairness. Point four, fairness of Igor Pobirchenko certainly created all the success of ICAC operations and reputations around the world. Since the very day of its creation in uh, 1992, this effectiveness is still with us. Point five, the fairness of Chernobyl is the bright light that was shared on many awards from arbitration practices. Let me share with you two examples. First, scientific meeting arbitration court in Belgrade. Igor was invited as an arbiter. During that meeting, the defendant asked to postpone oral hearings. Two arbiters wanted to accept this motion, and our knight was very convincing in showing that such motion would break the equality of the parties, which would make it unfair with regard to the claimant. Then they had closed session, and the panel that delivered the final decision after the lunch in the afternoon. The night canceled the booked hotel and went back to Kiev on his car with his driver on the same day. Another example, if we can show the picture, the photo, the arbitration court was considering two cases with the two defendants. The case file included several thousand pages, while the cost of the dispute was about several $1 million. During the oral hearings. Both parties spoke to this panel, including myself, asking the arbitration to deliver a word based on fairness. After that, certainly we lost the sound for, but far as here, the award was based on fairness. Point six, Pobirchenko's fairness is the foundation for communication between ICAC and most prestigious arbitration centers in Europe and world. Point seven, fairness of the Pobirchenko is the basis of his concern. about following the principle of fairness, which would be the key principle for the future president of ICAC. And he told me, now I am feeling fine when my alumni was appointed after many. I'm sure he will be the guarantee of following the law-based approach in operations and judgments of our ICAC. And the time showed that that was true. Point 8, fairness of Igor Pobirchenko is a criterion of his attitude with all actions and interactions in the society, including the people. He really demonstrated a lot of trust for me when he suggested me as one of the arbiters of the newly formed cake, which is still for me generates in me a feeling of a very high level of responsibility.
You will always be, for me, a theoretician, a practitioner, a leader, independent arbitrator, and a knight of fairness. And it was an honor and a privilege to meet with him, not only with regards to professional matters, he was also very hospitable, and welcomed me to his house. 9. The fairness of Igor Gavrilovich confirms the hypothesis that the life of great people that Igor Gavrilovich was starts on the day of their death. When I called Mykola Fedosovich in April 2019, 2012 to check if the sad news from Kiev is true, he said yes. Unfortunately, the death took our icon away. That was true, but the great mysteries of our existence are only about to be unraveled. Even death might turn out not to be the end, as the famous Serbian scientist Nikola Tesla said once. And 10. Um, Knighthood of Igor Gavrilovich, academician, professor, um, with degree in law, Ihor Pobirchenko will continue in the memories of future generations of lawyers. He will be remembered as a unique knight of fairness and arbitrator of fair resolution of disputes. Dear friends, I am so sorry for not being with you today, but using this opportunity, I would like to commend the organizers of these anniversary readings and the future readings, which are the best way to express gratitude to the honorary president of IPAC. Dear friends, dear colleagues, it was an honor for me to talk to my wonderful colleagues about the Night of Fairness. Thank you, dear organizers. I wish all of you peace and thanks so much. I think uh, nothing can be added to that. Now we're going to go on a 15-minute break. Thank you. You helped us go into the life of Ihor Pobirchenko, and we will always remember what his role was. Always in memoriam. So don't forget the sources of ICAC. So 15-minute break. Alexander, thanks so much for the presentation. Thank you, everyone. The best of success to you. I'm sorry for the delay, but it was a very interesting discussion, remembrance of of a great person. So now let's start our second session. And in my introductory remarks, I mentioned that we invited a lot of top-notch experts, and we have a guest in our midst, more than a guest. Roman is the head of some committee on enforcement of ECHR judgments and alternative dispute resolution. He is that kind of person who works with ADR and arbitration. And let me explain why I would like to give him the floor. During the meeting with the Committee on Legal Policy, which is uh, virtually the only body who deals with matters that are important to us, head of the committee, Denis Maslov, said that Roman will be dealing with everything connected to um, international and investment arbitration. So now, uh, uh, due to air raid sirens, the bridges are closed. So that is why um, he got delayed. And now I would like to give him the floor to speak about our roadmap because we are at the fork in the road. Now, Roman Babi, head of subcommittee at the Legal Policy Committee of the Parliament, member of the Parliament. The floor is yours. Thank you, Mykola Pedosovich, for such warm introductory remarks. Indeed, I was supposed to speak during the opening part, but due to the air raid siren, there was some problems with logistics. So I'll take a few minutes now. First of all, I would like to thank the organizers, Mykola Fedosovich, the leadership of ICAC. In these trying times, you are organizing such events. You are doing your best to the community in the loop, which is invaluable. At the same time, fortunately or unfortunately, we are adapting to war. But we need to remember that we have to move towards victory, each in their own place, in arbitration, in the parliament, in court disputes. But this is everyone's contribution to the victory. And of course, we need to be grateful to our defenders. And I would like to thank our armed forces because it is owing to them that we can have these events in a relatively relaxed environment, despite air raid sirens, because we're already used to that. And we have this opportunity to exchange experience and to develop professionally. In my remarks, I will not dwell on the importance of alternative dispute resolution, uh, including arbitration, commercial arbitration. You know that already, but sometimes I have to prove the worth of ADR to my fellow MPs, and I will not cease doing that. A very important element of achieving fairness is arbitration as well as other ADRs, in particular for businesses, businesses who value their time. time is irreversible. It cannot be restored. It's important for businesses and investors that we will hope will come after our victory during the post-war recovery. The time is valuable, and under current realities, fast operating business is a successful business. And unlike the general court system and traditional courts, this time for resolving a dispute, extrajudicial dispute resolution, commercial arbitration, it saves time for the parties. And the court system right now is experiencing turbulence. It has been for a certain amount of time. Uh, and judicial reform is still underway, still pending results. Uh, but even though the situation is not very good for a country, but it's still a window of opportunities for the ADR institutions. They need to prove their worth. They need to improve their reputation so that people would know about them. And at the very least, before uh, filing a lawsuit or submitting a procedural document to have their rights defended, they need to remember about national, domestic arbitration, international arbitration, or mediation. That would be a perfect situation. This is useful for the court system itself. Every time I'm trying to convince my colleagues explaining that this is timely, it's very much needed. I often say that by doing this, we will be helping the court system because we will be taking a burden off of it. The judicial system is uh, undermanned, and such institutions help judges have more time to more swiftly and with better quality uh, hear cases. I've been hearing various opinions, and I'd like to emphasize that traditional courts and arbitration institutions do not have to be competitors. They cannot be competitors. They need to see each other as partners, partners working for a common cause. And if arbitration institutions, domestic arbitration, operate well, it will be easier and better for the domestic court system to operate as well. And regarding opportunities and reputation, there's something I have to mention. Reputation is formed not by institutions but by people. People who work in various institutions, ICAC in particular, it's the people who form the reputation and respect for the institution. And after the full-scale war began, we uh, restored communication. After everybody went back to their senses, more or less, I was told that in 2022, IPAC uh, had more decisions compared to peaceful times. This actually attests to the resilience of the institution. This shows that those horrible challenges that our country is faced with did not uh, discourage ICAC, similarly to what happened in various other bodies. ICAC didn't leave to the safety of the western regions of Ukraine or Monaco, guerrilla partisans in Monaco. And even though I am a member of parliament, I was very happy to see that ICAC quickly um, reinstalled its operations. They are using online methods, e-decisions that helped in these trying conditions not to go back to the level um, that they had before the war, but even exceed those numbers. And our international partners, European Commission report actually specifies that, and Ursula von der Leyen mentioned that the resilience of the governmental institutions. But I would also like to note the resilience of arbitration institutions and ICAC, which in a short amount of time after the commencement of full-scale invasion continued their work and they were successful at that. I would like to wish you the best of success in your work. Keep up the good work. And I would like to wish to the participants of our discussion, our readings, productive work. Thank you. Thanks so much, Roman. Uh, Something to uh, inform the representative of the parliament. We actually received more cases this year than before November last year. So we have quite the prospects in Ukraine. We are grateful to you, Roman, for what you said, for your assessment and guidelines. This is very important because it's the parliament that forms state policy in this area, and it's such a pleasure that we are on the same page. You are a supporter of the arbitration development of Ukraine to the same extent that we are. I would like to invite Yulia, the moderator of the second session, and let me, uh, Yulia, please take a seat. I want to share a secret with you. Just don't tell it to anyone. Ihor Pohrebchenko loved beautiful women. And because of that, well, we have Yulia, which is beautiful, but she's beautiful and smart. She's very intelligent, responsible, and she's always persistent in her work, very meticulous, and she never gives up in her professional work. So I am sure that the session that she's going to moderate about what novelties arbitration institutions have to offer to the users is very important. If we do not develop, if we do not move into the future, we're going to drown. So, our next session. Good afternoon, everyone. First of all, it's such a pleasure to see all of you. It's been almost 2 years since our last similar meeting where we discussed various topics. And before we kick off our session, I would like to express my gratitude to Mykola Fedosovich, to the leadership and secretariat of ICAC. Uh, it is true. ICAC did not just not stop. It continued its operations under all sorts of circumstances. Throughout the entire duration of the full-scale war, the parties were provided with the opportunity to seek arbitration services for dispute resolution. And this actually highlights not just the resilience of arbitration in Ukraine, but a very high level of conscientiousness and professionalism. I would like to thank everyone. And without stopping for a moment, the entire arbitration community of Ukraine continues actively um, pursuing its cause, working with other arbitration institutions to improve the quality of arbitration services, to improve the rules of arbitration procedure, to provide the parties with new opportunities, which on the one hand are not actually caused by war, but there are uh, other needs as well, security in particular. There are other needs as well. It is to make arbitration more accessible, to introduce and manage cost efficiency, which is especially relevant for Ukrainian parties. Our session and the topic was selected for a reason. Despite the martial law, arbitration community keeps a close eye uh, on the new procedures and trends and tries to implement those that have already proven they're efficient. And as Mykola Fedosovich has already mentioned, it's also about those tools and trends that are in line with the Ukrainian context. It's such an honor for me to moderate this session, and well, first of all, it's because of my professionalism. So that is why, moving on to our discussion, I would like to first introduce our absolutely amazing speakers that will share with us the new arbitration practices, trends, and new challenges that arbitration has faced in such tech-savvy times. Serhiy Melnik, Deputy Counsel with the ICC, he will speak about expedited procedure dispute resolution. This procedure uh, was introduced around 7 years ago, and it is available to the parties if an arbitration agreement was concluded before March 1st, 2017. So there's already time sufficient to develop the practices of applying this procedure, and it would be very interesting to learn about its results. Serhiy Melnik uh, is also managing ICC cases with the parties from Eastern Europe. And in the past, he worked with various international law firms in Ukraine, Belgium, France. He has double legal qualification, and he devoted his professional time to commercial disputes. Our second speaker, Professor Martin Aslanovich, um, president of arbitration court at Leviathan Federation. He will focus in his presentation on the prospects of using mediation. Uh, can mediation become alternative to arbitration, or maybe there's a way to combine the two by the parties and to efficiently use them. Professor Aslanovich is not just working as an arbitrator and arbitration president. He has over 60 academic publications, three monographs, three commentaries, and he has over 25 years of experience of working at various law firms. He specializes in court and arbitration disputes. Our next speaker, James Freeman, uh, partner of a well-known uh, very law firm, which is renowned for its arbitration practice. He's the head of the London office. On more than one occasion, he was recognized as the best arbitration lawyer by various international rankings. He is practicing in area of arbitration with observance of the various rules of procedure, various locations, and he specializes in commercial and investment arbitration disputes. And now James is a member of the LCA board. That is why it would be very interesting to hear about LCA experience of using cutting-edge technology. And our last speaker, Natalia Patrick, Deputy Secretary General, Head of Business Development Section, SEC. Natalia uh, has uh, a powerful reputation, and she is not just a deputy secretary general, but she worked as a counsel and the secretary of the Mediation Institute and a Swedish Arbitration Association for Young Lawyers at SEC. So all of the speakers that were kind to agree to speak and to share their experience, I'm convinced, are going to share with us very useful, very relevant information um, that will be useful not just for us as arbitration institution, but also as a practice and arbitration lawyers, something that we will be able to put to good use. And regarding language and questions, we will have most of the speakers speak English. I will switch to English as well. So Melnik will speak in Ukrainian. So the first presentation is going to be in Ukrainian. I suggest we keep the questions for after the presentation and then ask them. Thank you, and let's start our discussion. And I would like to give the floor to Sergei Melnik. Once again, his topic is time is money, demand for expedited procedure for dispute resolution. And as I mentioned, ICC already has experience of use of expedited procedure, and I'm very interested in how successful it is, how needed is this procedure. Is it in demand by the parties? Be grateful for your insights. Good afternoon, dear colleagues. It's such an honor to speak to you, especially in Ukrainian language. I would like to share our experience with the expedited procedure. Let me say a few words about the difference between the standard procedure and the expedited ones. The standard procedure, in line with the ICC rules, there needs to be uh, a document signaling out the terms of reference that will lead to efficient dispute resolution. And this stage normally takes a month or two. The expedited procedure doesn't have the terms of reference at the stage. Then, regarding certain deadlines, in line with the standard procedure, there's uh, quite uh, a liberty present for the parties and for the tribunal uh, this is a case management conference, and in expedited procedure, it does happen, but it's in the course of 15 days after the tribunal was assigned. This is for this case management conference to sort of bring the case together and to give the opportunity to the parties and to the arbitrator to understand how to proceed. Regarding the time for drafting of the arbitration award, Uh, the timeline can be extended because sometimes the disputes are very sophisticated. There are several rounds of submissions. There could be hearings that can take place in the course of several days of weeks. So 6 months is not enough. And in expedited procedure, the secretariat and court are trying to limit the duration of the case with 6 months, only in special cases when the parties request so we can extend the timeline. But if that happens due to the violation by arbitrators, then their fees will be decreased because the very gist of the expedited procedure is for an arbitration proceedings to go very fast. In line with the standard procedure, the parties have full autonomy with regards to how arbitration is going to take place. They can agree about different number of rounds of submissions, about the documents that are to be submitted. And in expedited procedure, as I will show you later, arbitration institution restricts that parties in that to make the procedure go faster, to make it cheaper and more efficient. And later, this, of course, um, results in relevant fees. They are standard in standard procedure, and they are decreased in expedited procedure. So if an arbitrator agrees for an expedited procedure, they understand that they will be paid less, but the procedure is going to go faster. So for small disputes, everybody wins. And just to show you the areas in which expedited procedure is used, and the answer is in all of the areas that we work with. This is very reminiscent of the standard procedure. Most all of the disputes are in building, engineering, and energy. This actually shows that uh, uh, there are very small disputes that resolve really fast. Uh, in a sector that also can have large, hefty, slow cases. And that is why expedited procedure is quite preferable by the party. So some numbers, we have around 400 cases that were already considered or are still pending with the expedited procedure applied. Almost 300 cases the procedure was applied automatically, and we will discuss that in greater detail later. In 100 cases, the parties agreed to the procedure, which means that uh, um, there were no prerequisites for the procedure, but the parties knew about it and agreed. They consented to it. And ICC can offer this procedure for the parties even in larger disputes that are more complex in order to cut down on the parties' expenses and to will expedite and speed up the procedure. You can see other numbers here as well. In particular, um, the court has certain powers with regards to whether apply a procedure or not. The procedure is not applied in those cases when it well doesn't make sense. If a dispute is, let's say, minor in terms of some of the dispute, but it's very complex, or if there are a lot of submissions in the case, or arbitrators, a lot of documents, witnesses, etc., etc. In those cases, the court, upon the submission from one of the parties, um, will look into whether this procedure is expedient, because we are trying to make the procedure faster and cheaper for the parties, but we have to remember that the institution and arbitrators, first and foremost, need to be interested in the highest quality arbitration with all the evidence examined, witnesses heard, and in some cases, it is not the best expedient option. And we have some statistics about final decisions, around 100, and some numbers about the elements. Uh, in more than 150 cases, there was no document production procedure, which of course decreases the workload on the councils and parties, the arbitrators. And in minor disputes, it makes a lot of sense to cut down on expenses. And now, regarding the amount of dispute. When the procedure was introduced in March 2017, the new rules of procedure said that all of the disputes in which the arbitration clause was signed after the rules of procedure enters into effect, so after March 1st, 2017, in those disputes, automatically the expedited procedure is going to be applied if the sum dispute is less than $2 million. So, having looked at the statistics, the Secretariat and court established that a large number of disputes lodged with ICC is quite minor. So, several hundred thousand, a million, and average amount is $700,000. And the procedure, in line with the rules of procedure, is actually oriented towards um larger disputes. So it was decided to focus on smaller cases and to expedite those cases for the parties. And the amount that everybody agreed to was $2 million. But after a few years of practical application in 2021, after additional research into the topic, we realized that we need to increase the amount to include the category of the disputes that are not as complex, but they are more than 2 million. So now the amount is 3 million to help the parties save money and to speed up the case. And the rest of the provisions for the application of the expedited procedures are still the same. So this is for visualization. As you can see, the parties are not under obligation to go into expedited procedure. They can actually sign the arbitration clause in the agreement and agree not to apply the expedited procedure, the expedited procedure agreement. So they have to explicitly say that there is no need for the procedure. And I actually saw these clauses in my practice. And this is done for the parties to be sure that all of the procedures will be done in line with the rules of procedure. For example, terms of reference. And what's also interesting about the use of the procedure that might come as shocking to some is that when the arbitration clause specifies three arbitrators, where each party appoints an arbitrator, and the court or arbitral institutions appoints a third one. The court has the authority to appoint a sole arbitrator, even if the arbitration clause specifies three arbitrators. Why was it done? Because it was established that in many cases, the parties, when they are signing an agreement, especially in the larger projects where disputes might be large, there could be three arbitrators. And later, there could be a dispute for a small amount or for a large amount.
In fact, the parties become hostages of the situations. They need to pay bigger fees while the cost of a dispute is really minor. That's why this provision was created to allow the court within their competence to change the number of panelists so that a claimant can have access to justice. In general, this process is quite detailed. The Secretariat examines the case very diligently. It depends on the amount, in dispute details, documents, and then the decision is made whether one or three arbiters should be appointed. So these are three articles that I've already commented upon, but also I'd like to mention Annex number 6, where the arbitration court and the arbiters have wider powers to formulate the case. Sometimes an arbiter can see that hearings will not be required because, based on submissions from the parties, it's clear who will win. And the standard procedure stipulates that if one of the parties insists on hearings, then the hearings shall be conducted. But the regulation on speedy procedure defines the arbiter may decide not to conduct the hearings if, even if one of the parties insists. But the parties previously cited the regulation, there is a procedure of ICC, and thus their rights will not be violated because they agreed in advance that the arbiter will have the right to decide not to conduct hearing, which will only save a lot of money. And besides that, arbiters can limit the number of pages in submissions by the parties or put caps on the number of factual documents or any other documents. They also can limit the number of witnesses. So actually, it's up to the arbiter to shape out the proceedings to achieve maximal efficiency without violating the rights of the parties. Also saving money with councils and even saving time of the parties, which is important too. When a party objects against speedy procedure, then normally these objections will be referred to complexity of the case, when a big number of documents has to be reviewed, many witnesses involved, hearings will have to be conducted, jurisdictional issues. Well, of course, they are important arguments, and if we can see that the party is really right, and the case is quite complicated, and includes many kinds of evidence. And when we see that speedy procedure will not be ideal in this case, will not be appropriate, so it will not be applied. The question is whether there is any direct reference to speedy procedure. Is not raised because it's actually automatic provision. Another issue that I face quite often when the parties object is that the amount of the dispute has not been identified. Then you cannot really apply the procedure automatically. And there on our side, we conduct our own analysis of the related amounts, and we are trying to come up with the final amount of the dispute, although sometimes it's very difficult. And jurisdictional issues also can take place. Talking about statistics, I would think that the court would impose um, sole judge in exceptional cases is rather an exception than the rule. There were even cases when 3 arbiters were appointed instead of one because of complexity of the case. And the average amount done here is, as I said, is 740,000. Now I'd like to mention some types of reservations. Maybe the audience will be interested to look at that later. For instance, we can agree on applying this procedure in general in spite of the amount of the dispute. So then we can recognize the procedure applicable, or you can establish your own amount when the procedure will be applicable. And it's very flexible approach here, which is possible. And in fact, the parties may decide not to use the application to this procedure, mentioning that in their reservations. Thank you. No sound, unfortunately. Не маємо звуку. Звуку нема. Once again, thank you. And we're moving forward to our second speaker and second topic, Professor Slanovich, and his points about application of mediation and combined procedures.
Do you hear us?
Hello, do you hear me?
Yes, we hear. But do you hear me?
Yes, I do. Now I do. Yeah, there was a
Good.
short interruption, but I do.
It's good. It's so nice to meet you online. I'm sorry for that, but I hope that we will meet offline next time. Thank you for your acceptance of our invitation to join this conference. I announced the topic of your presentation, and that's why, first words, I would like to ask you: do parties in Poland prefer mediation rather than arbitration? Because in Ukraine, mediation is ongoing procedure. So I can say that it is so widespread and has obtained wide reputation, good reputation among the parties. What do you think? What is the situation in Poland?
Thank you very much. That's a very good question. Before I start answering, let me, however, thank you for inviting me and having me at your conference. I truly regret that I am not there in person, and I very much hope that next year, if I receive another invitation, obviously, I will have an opportunity to come over. The reason for me not coming over, it's not the Russian invasion, because I'm not worried about the Russian missiles as I see all you brave people struggling for the second year with the Russian invasion, but it's simply the lack of sufficient time to go for the travel to Kiev and back. But I hope, respectively, whatever the situation is going to be next year, I hope to see you all in person. Once again, many thanks for the invitation and having me here. Now, responding to this question, I think it's a very important issue which you just mentioned. The discussion about mediation versus arbitration has been going on in Poland for quite some time now, for a couple of years. And there are a lot of people who think that arbitration is the way to follow and everybody should focus on arbitration, while there is probably an equal number of legal practitioners who think quite the opposite, that it's the mediation, that the parties should settle the disputes via the mediation. But I think one does not exclude the other, meaning there is no reason to think about the arbitration and opt for arbitration and not to think about mediation, or other way around. I'm personally more involved with arbitration, but I have a lot of colleagues who spend their time mediating disputes and convincing the parties to have the disputes settled via mediation. So I think this is a very good starting point to say a few words more about the issue in question, meaning the arbitration and mediation. I hope my presentation is visible. If it is, I understand somebody will help me to put on the another slides. But in any case, the purpose of the presentation was to just give very short sentences constituting the ground for the discussion on the specified issues in more details. So even if we struggle with any technical problems, it shouldn't be an issue. So the subject of my short presentation was the discussion on efficiency of mediation and combined procedures for resolving commercial disputes. And I wanted to focus on, oh yeah, I got it here, many thanks. And I wanted to focus on few points connected with this subject. One is, which is on the first slide, what should be meant by procedural peace? What are the key principles of settlement of the commercial disputes? Now, the question here that I think we need to answer is how to make the disputes settled, whether we should make them settled via mediation or arbitration, but even more importantly, I would say, how to convince the parties that it's in their best interest to settle the dispute either via mediation or arbitration via an alternative dispute resolution method. And the issue that I've been facing in the last several years in Poland is that the most difficult point is to convince every participant of the process, meaning the parties representatives, and respectively the arbitrator or the mediator, that is in their particular best interest to have the dispute settled. Now, I have come across many times in my capacity as the president of the Corp of Arbitration at the Confederation of Leviathan in Poland, which is the, as you may know, the second biggest Polish permanent arbitration court, that either for instance, the parties' representatives were willing and trying to convince the parties that it remains in their best interest to settle the dispute and to get involved into mediation or arbitration, while the parties themselves were not willing to do that, or other way around, that the parties were willing to have the dispute mediated or arbitrated, while the parties' representatives, the legal advisors, the attorneys, were not that much into this. Now, clearly, if the arbitration clause was concluded between the parties, there is not much the parties can do. Theoretically, I mean, we go into the arbitration proceedings and the dispute is settled by the arbitration. But the question is, is it really one-way ticket? Meaning, do we really have to have the dispute settled by arbitration if we have the arbitration clause, or we cannot go into mediation? And the answer to this is negative, meaning in Poland, according to the Polish law, but I believe that probably the same laws would be applicable, the same principles would be applicable under Ukrainian law, but I would be very curious to hear that if it's the case indeed. There is nothing that prevents the parties to the arbitration clause to have the case diverted into mediation at any stage of the proceedings. Now, we in Leviathan were thinking how to make this happen structurally. I mean, how to convince systematically the parties of the arbitration proceedings to launch the mediation process during the arbitration case, meaning irrespectively of the fact that the arbitration case has already been launched, just to have a little pause of a couple of weeks or a month to get the mediator involved and have the mediation going on. Now, we've been discussing it for quite some time, but and eventually we came to the conclusion that it doesn't make sense to have it organized in a structural way. It doesn't make sense to enforce this vis-a-vis the parties. It's rather the role of the arbitrators, the arbitral tribunal, to convince the parties of the arbitration proceeding that now let's take a quick break and try to have the case mediated and have the settlement potentially issued much quicker. Now, we believe that it's the best solution because it doesn't have any involuntary aspect in the arbitration process. And again, it gives a pretty significant opportunity to have the case settled if the parties and if the arbitrators, most importantly, are convincing enough to the parties' representatives. One more observation before we jump to the next point and next slide is that we believe that it should remain in all the persons involved best interest to have the dispute settled via mediation or via arbitration. What I have noted as in my capacity again as the president of the Leviathan Call for Arbitration is that clearly not necessarily always the arbitrators are equally interested in having the case mediated, because if the case was already established, if the case is running, then they want to issue the verdict. They want to go to the end of the proceedings. They want to have the verdict, the case completed. And it very often or quite often shows up that the arbitrators are willing to continue with a case or eventually have the settlement concluded, but within the arbitration proceedings without appointing a separate mediator in the case. Now, clearly, it is the role of the arbitral institution of, in our case, the Leviathan Court of Arbitration. I believe that probably ICAC might be facing same challenges and difficulties in Kiev, just to make sure that really the arbitrators believe that it's in everybody's best interest to have that dispute settled by the professional mediator. Now, one more observation before I come to the role of the arbitrator and the mediator in resolving commercial disputes is an observation, again, from my perspective as the practicing lawyer for quite some time already, but also as the president of the Leviathan Court of Arbitration, is the answer to the question, when is a settlement satisfactory for both or for all parties of the proceedings? Now, is it when the parties equally lose the case or when the parties equally win the case? And as you may know, a lot of practitioners in Poland, but maybe it's again probably a wider observation, tend to believe and tend to say that a settlement is good and shows up to be a proper way of solving the disputes if the parties, if both parties, all the parties are equally dissatisfied with this contents, meaning everybody is a bit unhappy. And it's probably just as again, a lot of practitioners say in Poland that a court verdict is similarly good if everybody is equally dissatisfied. Now, I do not agree with this observation. I believe that everybody should be equally satisfied with the outcome of the settlement and the outcome of the mediation, obviously under the condition that it ends up the dispute, that the parties do not need to have spent more time and money and effort in settling it, in continuing to settle it in the arbitration proceedings. Now, this brings me to a few words about the role of the arbitrator and mediator. And clearly, a thorough discussion on all the issues connected with these topics probably exceeds the time that I'm given to present my thoughts during this conference. But I wanted to say that, again, from my experience, that two potential approaches show up. One is that the arbitrator / the mediator should be very active and trying actively to convince the parties to the potential solutions, to the potential settlement. And the other one, that the arbitrator or the arbitral tribunal or the mediator should be quite passive, meaning that it is in the parties and the parties' representatives' role to continue with this, with discussions, with the negotiations, and the arbitrator or the mediator should basically moderate the discussion only. Now, I believe that clearly the most important comment here would be, from my side, again, from my experience, is that it very much depends. And a good mediator or a good arbitrator shows up to be good, professional, and skilled when he or she adjusts those this approach to the specific case, to the specific individuals, to the specific subject merit of the dispute, because in each and every case this could very significantly differ. So there is no universal role or no universal raw model of an arbitrator or of the mediator in resolving commercial disputes. And in relation to the combined procedures, I just wanted to make one comment, is that I believe that it does pay off for everybody, and it's beneficial for everybody to join forces, to have the mediators supported by the arbitrators who have been leading the dispute, who have been solving the dispute, and providing the mediator with a hints on what are the key issues in the settlement process, in the dispute resolution process, and also other way around. Obviously, that goes without saying, to the extent that it's permissible under the local laws. In Poland, there are no significant restrictions in this regard, but I appreciate that various other jurisdictions may include different rules in this context. And for instance, for confidentiality reasons, the arbitrator or the mediator may not communicate with respectively the arbitrator and mediator in the subsequent proceedings on what he or she learned about the case. And this brings me to my last slide, which I wanted to say a few words about my observation on the current trends in international arbitration. And the question, what are the current trends? Are the disputes, are commercial dispute settled by mediation? Are the commercial disputes settled by arbitration, or which way of resolving this dispute is increasing? Now, I've been observing this for probably the last 15-20 years now. And what I note is that there have been a lot of discussion on this subject. A lot of practitioners expressing their positions and their observations. But in fact, the trends have not changed. What I believe, again, I might be wrong from other perspective than Polish, because my experience in settling the disputes is in other jurisdictions is certainly limited in comparison to my experience in Poland. But my observation is that it has not been changing remarkably over the last 15 or 20 years, meaning that a lot of people talk talk about mediation, arbitration. A lot of people try to convince the parties to settle the disputes via mediation, just to try to find a settlement. But statistically, it does not change a lot. Meaning still proportionally, not a very significant amount of disputes is settled by arbitration, and statistically, large commercial disputes are not too often settled via mediation. Now, this brings me to the last question that I wanted to discuss very briefly. How will the situation further develop, and whether this will change? Will mediation or arbitration constitute the larger proportion of the methods of settling the disputes? But I would personally say that I don't really think it's going to happen. Meaning mediation, in relation to arbitration, in relation to mediation, probably the increase will continue, but it's not going to be a very significant increase, because when the parties are in the dispute, when the parties want to litigate, when the parties want to arbitrate, they will do so. That it would be probably a little bit challenging, a little bit difficult to convince them that it's mediation is the best way to settle the dispute. But it remains very interesting to observe the further trends, to observe how it's going to further develop. And maybe already next year, when and if, I very much hope we meet, we're going to be able to say some comments and some conclusions in regard to what did happen in the last year, meaning the upcoming year. So that's on my presentation that I prepared, probably pretty much it. I hope I did not exceed too much of my time and your patience. Many thanks for hearing me.
Parties are always satisfied with the result if they reach it. But in comparison to arbitration, when one party is always unsatisfied with the result. So I think it is a big advantage of mediation in comparison to arbitration. Thank you. We are moving to our next speaker, James Freeman, who is going to present one of the most pressing issue now, e-arbitration, how technology impacts arbitration. James, it's nice to meet you this time online. I hope that next time we will meet again offline in London. And I know that you are so much experienced arbitration practitioner, and worked with lots of arbitration rules. And I'm sure that you used different online filing systems of different arbitral institutions. Could you please share your experience and provide your thoughts regarding whether all platforms, all programs, all online systems are so convenient for the parties that they are similar with their tools, or according to your experience, parties still inclined to use, let's say, classical tools to send the submissions online or using post services?
Sure. So you're hearing me loud and clear, are you?
Yeah, we hear you well.
Great. First of all, lovely to join everybody. I'm sorry it's only online this time. Yulia, you said offline in London. Hopefully it will be offline in Kiev.
Yeah, definitely.
And I must say, I'm delighted to be able to join a conventional discussion on international arbitration, which I think is a great reflection of how far Ukraine has come in the last 20 months. As you said, my topic is e-arbitration, how technology impacts arbitration. Now, in a sense, technology impacts everything we do in arbitration. We draft electronically, we communicate electronically, we research electronically, we store information electronically. I can't cover all of that in 20 minutes. As you said, the overarching theme of this session is about arbitral institutions. So I'm going to concentrate on how international arbitral institutions use technology. And I want to identify, I think, two main ways in which arbitral institutions use technology. The first, and you referred to this in your opening remarks, is that I think the most notable way in which arbitral institutions use technology is to improve the management of their case files. Most of the major international arbitral institutions now offer some online case file. I think that the start of this trend can be traced back to the launch by the LCIA of their online filing tool in 2014. So with that tool, it's possible to file a request for arbitration or a response, which is the LCIA equivalent of an answer under the ICC rules, or an application for the appointment of an emergency arbitrator, or an application for the expedited formation of the tribunal online. And it's also possible to pay the requisite fee for each of those steps online as well. So that was the LCIA in 2014. That's been followed by the launch of some more comprehensive tools, I think, by various other arbitration institutions. And I would note first the launch of the SCC platform in 2019. So whereas the LCIA tool is just about the filing of certain specific applications, the SCC platform is intended to be a database of all the documents in the case that pass between the parties, the arbitral institution, and the tribunal. And then other institutions have launched similar tools subsequently. So the Hong Kong International Arbitration Centre has its Case Connect dating back to 2021. The ICC has its Case Connect, the same name, in 2022. And I understand that the Singapore International Arbitration Centre is currently working on a similar tool. And I know for a fact that the LCIA is too. I think there's a lot of similarity between these platforms. Fundamentally, all of them are providing the same service, which is, as I say, to provide a single database of the documents in the case, at least those that pass between the parties in the tribunal and the arbitral institution. There are some variations between them. So, for example, as I noted, the LCIA online filing tool allows for payment. I don't think that's possible under all of the platforms. The SEC and the Hong Kong Centre provide a case calendar on the platform, and the ICC tool provides for electronic filing of forms relating to arbitrator disclosures, for example. So there are some small differences, but I think the similarities between the platforms are greater than the differences. So let me make a few observations on the development of these case databases, and I've got 6 observations. The first is, I think this is a welcome advance. I think it's more in the nature of a development that allows arbitration to catch up with the rest of the world rather than move ahead of it. In some ways, it's remarkable to think that less than 5 years ago, we were all filing requests for arbitration in a hard copy at the majority of arbitral institutions. Even the English court, which is not renowned as an early adopter of technology, had an online filing tool before most arbitral institutions. But it's good news that we have caught up. Second observation, clearly a critical concern with these databases is cybersecurity. Arbitrations frequently involve issues of a high commercial sensitivity and potentially political sensitivity too. Now, this appears to be recognized and understandably treated as a priority by all of the arbitral institutions. It's interesting that, as I understand it, they all use the same technology, which is a system called HiQ, which is a product of Thomson Reuters. And I suspect that many of you in the room will be familiar with it because it is routinely used, in my experience, by many law firms, including my own. We use a version of HiQ to offer an online platform to share documents with clients and indeed with other parties like experts. In a sense, one might take the view that storing information electronically on these platforms potentially makes it more secure, considering the old system of paper files had in its own way vulnerabilities. But clearly, cybersecurity is a very important concern. The third observation is that none of these platforms are compulsory, but to answer your question, Yulia, about how far they are used, I only have anecdotal experience of my own and those who I've talked to, but my experience is that where these tools are available, they are used for the most part. And I think that must reflect that the users view the development of these case databases as a welcome development. It is convenient for all documents in the case to be found in a single place that can be located online with ease from wherever you are. Interested to know whether Natalia and Sergey, who of course are both at arbitral institutions, have their own insights on that. My fourth observation is that the use of these case databases does put a certain responsibility on the arbitral institutions. Previously, the management of the file was a matter for the parties and to an extent the tribunal. That responsibility to an extent has now passed to the institutions. Now, that should of course be fine because the arbitral institutions are all staffed by highly professional and able people. My own experience is that nevertheless, it's not completely fail-safe. I had a recent experience, for example, of having to track down an answer in a case which we worked out must have been filed but couldn't be found on the database. So I think just in practical terms, there remains a responsibility of diligence on the part of the parties to track what's happening on the database, even though the responsibility for maintaining it is out of their hands. Fifth observation is these online tools are great, but they are not a complete solution to document management in an arbitration. I mean, to take an obvious point, they don't cover correspondence between the parties, which, if you're counsel in the case, is obviously an important category of documents. And of course, they're not going to manage the documents that you are managing with your client about the preparation of your case. I think the platforms are also not a complete solution because their functionality goes a certain way, which is great, but there is further functionality that cases often call for, which these platforms don't provide. That's not intended as a criticism, it's just an observation of how far the platforms have gone. So to give an example, if you were doing an online hearing, as we all did between 2020 and 22, and we continue to do to some extent subsequently, you would often have a hearing bundle with hyperlinks to exhibits, potentially to the hearing transcript as well. That's part of the case file, but that's not offered by the platforms, at least currently. Let's see what happens in the future. And indeed, that's my sixth observation. What comes next? I think there is scope for further development of these platforms. For example, wouldn't it be great if at a point in the future, your case file as held by the arbitral institution included that kind of integrated hyperlinking between the submissions and the exhibits and to the hearing transcripts and so forth. That functionality is currently provided by other software, but I wonder whether a day will come when it all becomes integrated into a single arbitration solution. So I think there's further scope for innovation in this area, and I wholly support any initiatives by the arbitral institutions in that direction. So I said there were two areas of the use of technology by arbitral institutions. That's the first one, these online tools. The second one, and I can be briefer about this, is how I think arbitral institutions are using technology to improve transparency in arbitration. You'll all be aware that there is greater public policy interest in transparency in arbitration to counter the impression that it's secret justice. That pressure is particularly marked when there are public interests in play, as there are in treaty cases and in many commercial cases too. Of course, initiatives to improve transparency are not completely dependent on technology. And to give you a couple of examples, the ICC has been publishing anonymized excerpts of awards in its bulletin for many years. Similarly, the LCIA has been publishing decisions on challenges to arbitrators since about 2010, and the SCC similarly has got what I think is a great arbitration portal, which informs the non-Swedish lawyers like me about relevant case law in Sweden relating to arbitration. But whereas these innovations could be paper-based, as they have been in the ICC bulletin, at least originally, I think it's great that some of these initiatives are now taking place online. And in fact, I just mentioned the SCC's arbitration portal, which I think is a great example of how transparency is enhanced by putting materials online. And similarly, the Hong Kong International Arbitration Centre has a product called Case Digest, which won the GAR award for the most innovative product a couple of years ago. That essentially puts online anonymized decisions by the HKIAC on procedural matters, such as on whether a case should be expedited, whether to appoint an emergency arbitrator, when cases would be consolidated or when parties would be joined. This is all really useful stuff that you don't find in the rules themselves. And in making a judgment on these kind of applications, parties are currently dependent essentially on the judgment and experience of their counsel. But by putting these materials online, the HKIAC is basically leveling the playing field and giving users insight into how secretariats at arbitral institutions approach these procedural questions. And I hope that other arbitral institutions follow the lead of the HKIAC, as some of them have done in part, as in the case of the LCIA with its decisions on challenges to arbitrators, for example. Finally, what more can arbitral institutions do in the technology realm if we look ahead? Just a couple of thoughts. One, I've already mentioned, which is, can the online case files become more advanced and user-friendly? I think there is scope for further innovation there. I think, secondly, will institutions become more involved in the hosting of hearings? Of course, hearings have become increasingly online in the last few years since the pandemic. To some extent, they've come back to being in person again, at least as regards final merits hearings. But I think we have taken an irreversible move towards hearings being virtual, either wholly or potentially partially, where, for example, minor witnesses will not be asked to travel and appear in person, but will appear virtually. Now, some arbitral institutions are closely involved in the hosting of hearings. So the HKIAC has its own hearing centre. The ICC hearing centre is closed in Paris at the moment, and I imagine that is to increase the functionality that is offered by the hearing centre, which I think is great. That's the use of technology by arbitral institutions. There is, of course, a broader perspective about the use of technology in arbitration more generally. Of course, the really hot is artificial intelligence, which is a topic for a talk in itself. But I don't think any talk on technology can be complete without at least a reference to it. I know this is a subject you're interested in, Julia. I mean, in short, it's clearly going to be a game changer for all of us. In my experience, ChatGPT is already one of those tools that we all use, and the question is more, how do we use it responsibly and appropriately, rather than should it be used at all? And of course, the question on all our lips, are we all going to be out of a job? I'm just going to leave that as a question for now without seeking to answer it, because I think I've spoken for long enough. Thank you very much indeed.
Thank you. Thank you, James, for your comprehensive report. I'm definitely sure that there is lots of space, lots of areas for further development and further discussion of e-arbitration and new technologies, how they can be developed, and they raise new issues such as cyber security, for example. And I'm sure that next time we will discuss cybersecurity issue, the matter of importance, rather than how to use technology at this moment. Thank you, James. So we are moving to our last speaker, Natalia Patrick, and her last topic of this session will be arbitration all-inclusive, extra services of arbitration institutions. Natalia, nice to meet you. Thank you for joining us this day. And I would like to ask you, we all know that Stockholm Chamber of Commerce Arbitration made or provided a wide range of new services, and this institution was one of the flagmen of new technologies, new proceedings. So, what was the reason of them? Which challenges the arbitral institution faced with that inclined to change the approach? Natalia, we don't hear you. We can't hear you, sorry. No. Do you hear me? So only we can hear you. Я думаю, що зараз Наталя підключиться заново, і ми почекаємо трохи. Зараз є час для обміну думками. Або можна ставити питання, які надалі потім перевести на наших спікерів. Може, є бажання у когось поділитися думками? Куди ми будемо рухатися наступного року?
Can you hear me now?
Yes, Natalia.
Perfect.
Just
Thank you.
yes. Nice to meet and hear you.
Well, the same here. Nice to meet you.
Навзаєм.
And I hear you very well. Hope you too. Good afternoon, everyone. And well, I am the last speaker. I understand we are running out of time, so I'll try to be brief and concise on my topic. And my first reaction, first, I would like to congratulate actually International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry on their fantastic development. It's an institution that we have very good relations with, and the SCC was one of the first institutions to help Igor Gavrilovich Pobirchenko to create and develop this institution. He was a great visionary. I knew him personally, and I have fantastic memories of cooperating with him and visiting Ukraine. And I also know that a lot of my peers and colleagues who were with me on different trips to Kyiv and meetings with Igor Gavrilovich had fantastic memories of our cooperation. So going over to my topic about arbitration all inclusive, my first reaction when I heard this topic was that of course, Western arbitral institutions have the tendency to develop new rules and procedures to better serve the parties. And this basically points towards an intention of the institutions to tailor their proceedings rather than to include everything possible into one set of rules. They try to develop new sets of rules that are suitable for different kinds of disputes and situations. And this is a big trend, which is not actually a very new one, such as, for instance, development of expedited proceedings. It's something that many arbitral institutions do have in order to meet the requirements of the parties to have a very light touch and not inexpensive arbitration procedure to handle small disputes, for instance. There are also other types of proceedings, and the SCC recently introduced the SCC Express assessment rules, and this kind of procedure is not about arbitration. It gives parties the possibility to request appointment of a neutral evaluator who would deliver within 3 weeks, as from the referral of the case to such an evaluator, who would deliver an expert opinion on possible outcome of the dispute between the parties on the legal issues. So it's kind of legal evaluation of the dispute, a very, very early one, which the parties nevertheless can accept as, for instance, settlement, can agree on the inclusion of such expert evaluation into their settlement, or even convert into an arbitration award. Everything is in the hands of the parties. So when coming to many arbitral institutions, especially in the western part of the world, you will certainly find a lot of different procedures and rules, and I'm not going to dwell on them. Many of them are quite technical ones, but I think that that was one of the biggest trends, actually. What we see now is rather a very, very fast development of policies, and policy has been a big trend over the past 10 years, perhaps, in different directions, I would say. And this is perhaps is the development which is due to the basic mission of arbitral institutions to be the gatekeepers of dispute resolution procedures, and to be the organizations who can actually develop best practices. And perhaps you know already there are a lot of very good initiatives out there on international arbitration arena which promote, for instance, diversity in arbitral appointments and open up career opportunities to a more diverse group of arbitrators, which promote greener arbitrations, that is, arbitrations which are more environmentally friendly. There is also another huge field, actually, that we are facing due to the current geopolitical situation, primarily due to the Russian aggression against Ukraine, and this is sanctions. We all know about sanctions, and the European Union introduced a very comprehensive sanction program against Russia. Many other countries followed the same trend, and this also creates a completely unique and new situation for arbitral institutions who have to follow the sanction legislations in their respective jurisdictions. And one of the first questions that we faced in this respect was how much we should guide the parties and arbitrators, that is our users, throughout the sanction legislations in order to adopt the arbitration procedure and to make it accessible. Because as we know, the arbitration procedure involves at least two parties, not only the sanctions party, it's also there is another party in arbitral proceeding, which can be also affected if the sanctioned party does not have access to arbitral proceedings. So we have dealt with all those questions in the past years, especially intensively in the past 2 years. And we elaborated on new routines of the procedure, which would actually allow us to handle cases involving sanctioned parties, but also cases requested against the sanctioned parties by the parties which are not affected, in order to both follow the sanctioned legislations, but also to make it possible for the parties to continue the proceedings. And this was a completely new challenge. That is not only a legal challenge, it's a big practical challenge, because we have to deal with banks which were very much uncertain, especially in the beginning of that situation, how to deal with the funds, how to transfer, whether the license is needed, whether it's not needed, and so on and so forth. So I think that now most of European arbitration institutions face the same situation. The SEC was one of the leaders who dwelled on all these issues, and we had also a joint project with many European arbitral institutions who requested various kinds of clarifications and obtained even an exemption for legal services under one of the sanction packages against Russian Federation. So there have been a lot of developments. So my topic is extremely broad. Again, my very general conclusion is that in the coming years, we will see, of course, a bigger demand for policy regulations, a bigger demand for, as it has been already said, transparency, perhaps new rules of conduct for arbitrators as well. And this is already a project work done by the UNCITRAL, for instance, UN Commission on International Trade Law, which elaborates on codes of conduct for arbitrators, primarily in investor-state arbitration, but the code is actually open for application even in commercial arbitrations as well, which actually sets internationally accepted standards for different kinds of situations which might imply conflicts of interest and so on and so forth. So that is my very short conclusion about the perhaps most burning trends currently. And those trends set completely new arena for operation of arbitral institutions, which now have so much more complex environment. We have to deal with technical issues, and this is also our future, because technical solutions that have been now discussed will facilitate a lot for our users, and indeed the platforms and various kinds of integrated solutions is something that we are currently evaluating and looking at. Here are just to answer the call and questions of the previous speaker. It's all those developments, for instance, bundling and allowing parties a possibility to use an integrated bundling system on the platform implies a huge investment. And of course, it's not only about the time, it's also about the money. And therefore, perhaps we do not see immediate solutions for this, which were not implemented, at least together with the platforms, but will perhaps be available in the close future, just as online hearings that perhaps 5 years ago were extremely unusual, and now they are more or less our everyday life because they facilitate a lot for the parties, for arbitrators, for everyone. So we have all these challenges and also opportunities in the future, and even basically here and now. And arbitral institutions are very well placed to deal with them. And I think that one of the ways to deal with them more efficiently is to cooperate more between arbitral institutions. I'm very happy that we actually cooperate with many arbitration organizations and institutes. Last year, we also signed a friendship agreement with International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry. And we look forward to some joint projects. We look forward to exchange information about good arbitrators in our respective jurisdictions. This is one of the provisions in our friendship agreement. And this will expand opportunities for the arbitration community, both in Sweden but also in Ukraine.
To finish our session, I know that SCC provides some educational program for arbitrators. Could you please share some thoughts, ideas, why you launched this program, and what arbitrators and arbitrator practitioners can take from it?
Thank you for the question, Yulia. Actually, yes, I'm currently working on the 2024 program for international arbitrators. All of you certainly know that arbitration is an extremely competitive branch, and there are a lot of good young specialists who would like to upgrade their careers and to be appointed not only on domestic arbitration, on the level of domestic arbitration courts, but would like also to be considered by international arbitration institutions. And given that we operate with basically an international environment, but our arbitral proceedings have a seat, a legal seat somewhere. In most of the cases, speaking about the SEC, the seat is in Sweden, then of course there is an expectation for us when we, and also our parties, of course, that persons and arbitrators that we appoint are well versed in the law of the seat, that is Swedish law. And this is the purpose of the course, actually, to give a very substantial introduction into the current Swedish legislation, case law as well, and also to train arbitrators to deliver best service to the parties when sitting as an arbitrator with a legal seat in Sweden.
Thank you so much. Шановні учасники, зараз
Для арбітра навички. Well, dear participants, we still have time for maybe one or two questions, if you have any, to our esteemed speakers. Looks like everyone is prepared to discuss what you heard in less formal situation, having a glass of champagne. So it's a pity we do not have a number of speakers offline. We could share with you the champagne, but so far, thank you very much for your participation. Before thanking all, actually, I'd like to address Natalia Petrik if she's still with us. Can you hear me, Natalia?
Yes, Mikola Milosevic, I can hear you well.
Я ловлю на слове.
So I want to catch you at your word. You mentioned our agreement. We are slightly behind you in some areas like online platforms. Yes, we moved to e-document control. I don't want to offend my colleagues since this was not that. Mm, we had conversation about your platform when we met in Poland. I want for your invitation. I do hope that in the very soon we'll send you request for cooperation. And thank you for reminding us, and we will always remember that how you helped Ukrainian arbitration in our development and taking solid position. I remember I personally had meetings with you in Sweden where we had discussions around this arbitration issues, but we were just beginners in this area. Um, Still, I'd like to say that once again, I don't know about your opinion, but for me, I think we made very good choice with regard to topics of this arbitration treaties. I will start with the second session. Natalia, you stated very righteously that now you mentioned this word of competition. Competition among the arbitration institutions, that's point one and second. Arbitration institutions have now to respond to new challenges. If we hadn't had COVID and many other phenomena, probably we would have that speedy re speedy transformation towards electronic proceedings. Still, we already got used to it, although there's some negative impact of that, but I don't want to discuss it now. So, on one side, it's a big pleasure for me uh, to see the fact that our arbitration institution can see all these challenges and the response to them properly. I want to thank all the speakers of the previous sessions for drawing our attention to new approaches, new challenges. We certainly are aware of them. I also mentioned the matters of sanctions that for us, European Union, United States, not only them, but also our state imposed several thousand sanctions over several thousand entities. So now we often have to consider cases related to the parties subjected to sanctions. So, in theory, we are quite successful in that, but how a company, sanctioned company, can comply with award provisions? So they say that that's for me a force major that will just destroy me. And the state of Ukraine imposed the sanctions on some foreign enterprises, preventing them from any financial operations so they cannot comply with their obligations. So, how can I really comply with my obligations if your country have imposed sanctions against me? What is it? So, in this case, like sanction works in the favor of debtor. So we need to have very good thinking around it. I don't want to discuss any constructs that we are working on. We actually had number of sessions with participation of state authorities um, associated with this action. We had certainly our sessions, so you help us a lot indeed. In spite of my age and some experience, I'm still learning from you too. So all of your presentations are very interesting and exciting for me. They make me think how I can apply some know-how that you mentioned, including online platform. By the way, Natalia, we would like to have your assistance in creating a platform like yours. I know you will say no, but anyway, we'll try. Second point, speaking about the first session, I'll say it again. All of us obtain the vision of where to go. And it's not just about experience. We we are not trying to copy paste, somebody else's experience. We have to actually deal with our realities. First of all, the war may it be damned forever. So I want to apologize for some delays, but that's quite an interesting cause. There are many issues, many questions, so we try to match the schedule. It's same thing as arbitration hearings. Looks like should be 6 months, but there are many cases where they go faster and many cases where they go slower. So, dear friends, I am not sure about your impressions, but we saw really robust, I would say, moderators and speakers. I'm really excited with your work, with your speeches, which were really inspiring us to, on one hand, we're already moving in line with the global trends, but we certainly can see the need to expedite some of our efforts, especially with regard to innovations, to actually catch up with the global arbitration leading trends. I'm not talking about competing, who will be the first, who will be the last. But, I'm just talking about the quality of the services that we are providing, how convenient they are for the citizens, and how objective they are. So once again, I'd like to thank, first of all, to the moderators and speakers for delivering all this information, and actually, which was really intellectual satisfaction for all of us. I want to thank you for your participation in the event, including representatives arbitration institution from Stockholm International Arbitration Court, very good presentation, and Polish arbitration. By the way, last year I asked to the president a question. He said that 70% of cases that they consider are solved through mediation. And I said, how do you manage this? He's very proudly said, we get to persuade parties. We are still not good at it, I think. We wrote perfect mechanisms when mediation, hybrid procedures should be used, including even financial incentive for the parties. If I'm not mistaken, there was only an attempt to start mediation to solve a dispute, but then it was stopped, and there were two attempts of combined procedures, arbitration, mediation, then arbitration again, and the parties decided not to use mediation, and they uh, filed their documents with arbitration again. Uh, so There are, of course, also issues with speedy procedure, but they are not relevant for us because we're trying to organize the process the best way we can, and we really managed to consider some number, some quantity of simple cases with a very good speed. I am not tell you how because you will steal our positive experience. So my special thanks to all representatives of the arbitration institutions and to representatives of ESAD program Justice for All. This entity has been working in Ukraine in a very robust way, and we've been always trying to cooperate with them. I wanted to use the word impose cooperation to them. Well, but the best to say would be to arrange cooperation. We make several tries. This have some critical attitude to our activities. We had a meeting with David, the head of this program. I think we found common grounds, and we will be thankful to receive the assistance in and improving of our arbitration activities. Second point, this conference was a success, of course. We managed to combine very successfully the commemoration of Professor I.Pobirchenko. We, of course, recognize the merit of those who were brilliant at what they were doing. And I urge you to always remember those who did something really important, not only in building the state of Ukraine, but in some very specific areas of state construction, state development. Uh, because now there is a trend to criticize some of those who played very important role. I think that becomes a national tradition. I really would like to avoid it. I mean, I do not observe continuity. Well, continuity is something we need, but here you get a new leader or new ICAC president, and then he just changes the course by 180 degrees. That's not right. We would have been that successful unless we had had the strong informational support that we had. And I need to say, we certainly need to do a better job to maybe promote our institution better. That's my fault, of course, first of all. We want to change the situation for better. This line of our activity, many of us believe that we should do our job without unnecessary advertising, but it's important sometimes to present your image properly. We had the representative of the parliament. I have a lot of respect for him. He said that the field of activities expansion. Actually, he said the judiciary has been reformed for 30 years and nothing happened. But I thought about saying that you just can't cancel this branch of power when that's terrible condition, when And I wanted to advise them stop reforms because it's terrible when a single one of branches of power is under continuous transformation and reform. Now they so resulted in a situation when many areas of Ukraine just do not have courts in place. And that's about protection of key rights of Ukrainian citizens. So let me even read who was supporting us in the information area, our unchangeable partners, the publication, jurisdiction, practical legal practice. We have very good relations with them, and I'm really thankful to stand for support of our arbitration system. They are highly qualified people, legal newspaper, Bar Association of Ukraine. We established very good cooperation with them. Ukrainian Arbitration Association, National College of Councils of Ukraine. So what I want to say that we decided to really turn our faces to the bar, and we will have support from Baltic Arbitration Days, so called this for the first time. It's a pleasure for us that even with arbitration, the Baltic states provide us with support without saying about their support against the military aggression from the Russian Federation. I would like to thank our interpreters who have done a lot of work today. Thanks God that they do not seem tired, judging by their interpretation of Kashmir-centric team. Our thanks. That's image building policy. This is what we do through you, esteemed ladies. So let's really raise that to even higher level. And I cannot help but mentioning, although this is my last point, the one who wrote this paper for me, I said it on the purpose. I didn't want to unmute anybody because the people get offended. So still, somebody was admitted. The staff of the Chamber of Commerce, I need to recognize the American, they are very supportive to activities of Arbitration Institute, and all of them fulfill all of our wishes. Yes, we pay for that, but they do a good job. They did great job. Just look at this room, how well it is done. Plus 2 days ago, there was big event here. They worked like 24 hours to make it all clean, to make it all nice and tidy. So what was not written here? We want to thank also the secretariats for our institutions. I think the moderator said that we want to thank secretariat that organized all this. By the way, speaking about secretariat, we probably are the only, how do I say it, that institution with a long vision. We now have two formats of communication with the parties. First, it's electronic, and plus, it can be in the hard format papers that can be sent by regular mail can be served to the representatives, so they are under double load. We are afraid of switching to electronic format because we don't know what would be the reaction of the judiciary because the party may claim that they failed to receive some material. So it's been for a year or even more. We do that. So the second session was about these online platforms and switch to e-arbitration. So now we are at this crossroads. This is just a period of time when our judicial system and us, with assistance from our colleagues from other arbitration institutions, very soon, if the circumstances permit, we'll switch to fully secured on one hand, and on the other hand, fully transparent arbitration in electronic format. That's our goal. Otherwise, probably we will not have good future. That's why I'm also very thankful. I can see that many of you stayed still here, not just to have fun at session number 3, but I understand many people are busy, so they left, including our arbiters. So I'm thankful to all of you. I wish you peaceful skies and to all Ukrainians victory with minimal victims and minimal sacrifice. And we will see you at the next 11th arbitration readings. Thank you all for your attention. May I already